All right. So we'll sort of kick the can down the road on the conflict part of it. All right. Any disputes arising out of this competition must be reported in accordance with the competition rules. Please remember that your compliance with time requirements will be considered in scoring this round. I want to confirm that no coach or team member other than well, never mind. All right. So we'll start now with introductions and then we'll swear everybody in. Let's start just randomly with Team Kenya.
Yes, Your Honor. Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Anna Seaman, and today with my co-counsel, we represent the people of the state of Colorado versus Avery Becker. Today, I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, as well as delivering the closing argument. Permission for my co-counsel to introduce themselves?
Yes, thank you, Ms. Seaman.
Good afternoon. My name is Leah Dino. I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins.
Thank you.
Good afternoon. My name is Thomas Dineza, and I will be delivering the opening statement for today's case, directing Mr. Kyle Kuzak, as well as crossing Professor Blake Van Owen. At this time, we ask that our witnesses be able to introduce themselves.
Yes, thank you, Mr. Dineza. That will be granted.
Good afternoon. My name is Dirksen Brinkerhoff, and today I am Detective Jordan Markowitz.
Welcome, Mr. Brinkerhoff.
Good afternoon. My name is Owen Holbrook, and I am Alex Cifuentes.
Thank you, Mr. Halrook.
Good afternoon. My name is Michael Dudzik, and I am Kyle Kuzak.
Welcome, Mr. Dudzik, as well. All right. Team Israel, please.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Moraine, and I will be conducting the direct examination of Blake Van Owen and the cross-examination of Jordan Markowitz.
Thank you, Ms. Moraine. Welcome.
Good afternoon, Your Honor. My name is Adele Donda, and today I will be conducting the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, and the opening statement.
Welcome.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Audrey Davies, and I will be conducting the direct examination of Avery Becker, the cross-examination of Kyle Kuzak, as well as the closing argument.
Thank you, Ms. Davies.
May our witnesses now introduce themselves?
Yes, please.
Thank you.
Hello, Your Honor, members of the jury and opposing counsel. My name is Taylor Davis, but today I am Blake Van Owen.
Welcome. Thank you.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Tommy McKissick, and I will be playing Taylor Perkins.
Thank you, Mr. McKissick.
Good afternoon, Your Honor. My name is Millie Bjork, but today I am Avery Becker.
Thank you, Ms. Bjork. All right, is that everybody? Let's start with our oaths. So please, team members, raise your right hands and repeat after me. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and the rules of this mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Anybody,
Yes, Your
any
Honor.
no's?
Yes, Your Honor.
Okay. All right, good. Thank you. Witnesses, raise your right hands, please. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions that are not contained in the case problem, and that you will follow the rules and the procedures of this mock trial competition?
Yes, Your Honor.
Absolutely.
Any no's? Okay. Hearing no no's. Any gallery members, including teachers and coaches, family members and friends, please raise your right hands, virtually or otherwise. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship both during and after this mock trial competition? That's a loud, resounding yes. And finally, scoring panelists, please raise your right hands. Do each of you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Excellent. Thank you.
Yes, Your Honor.
All right. Thank you all. All right. So let's settle in and we'll start with any preliminary matters that either side wants to raise, starting with the people.
Yes, Your Honor. The people request that the stipulated facts be entered into evidence and constructively read to the jury.
Is there any objection from the defense?
No, Your Honor.
All right. So that request that the stipulated facts be read in the record. Of course, we're only going to do that figuratively at this time. That will be granted.
The people would also like to confirm screen sharing during the trial. What we've done in the past is once the exhibit is being talked about, we share it on the screen, but it is constructively hid from the jury until it is entered into evidence. And we would like to make sure that that is acceptable for the court.
Yeah, let's hear from the other side. I mean, certainly I don't see a way around that, but let's all get on the same page. So I'd like to hear from the defense.
Your Honor, that should be fine. Generally, we lay foundation for the exhibit, and then at that point, we publish it by screen sharing it.
All right, Ms. Moraine, I think that's good. If there are any issues that arise, we'll deal with them as they do arise. So thank you. That request will be granted, Ms. Seaman.
Yes, Your Honor.
Any other issues?
Finally, we request that any remaining time on closing argument be reserved for rebuttal.
That will be granted, of course.
And
All right. Anything from the defense? I assume that the defense is incorporating the people's motions, but anything more?
Your Honor, if there are any technical difficulties, we ask that time be stopped for both teams.
That is a great point. I appreciate it. You're raising it. There is one exception other than the emergency rule, and that is the somebody falling off into Neverland. And so when that happens, we'll ask the timers to stop time, and then we'll give a reasonable amount of time for that other person to rejoin. And then if it gets a little bit crazy, and that of course will be true with respect to the judges, but if it gets crazy, we're just going to ask somebody to cover, and then we'll really see what everybody's made of. But I expect that'll be fine.
Thank you, Your Honor.
Any other pretrial motions? Or any other pretrial matters, and then we'll move to motions in case there are any separately. All right. All right. So anything else from you, Ms. Moraine, as at this point?
No, Your Honor, that's everything.
All right, good. Is there anything else we need to do before we commence?
No, Your Honor, the people are ready to proceed.
All right. In that case, and here's what's going to happen. And those of you who just have had the misfortune of having me be your presiding judge before, I always say that I'm going to take a break in between witnesses so that our scoring judges will have a chance to make notes. And then I invariably forget to do that. So if anybody wants to chime in and remind me, no offense will be taken, I promise. It's just something I forget to do. I've asked my clerks to remind me to do that in jury trials in court, and they have to get up and throw things at me. So that said, let's start with opening statements. And I forgot who's opening on behalf of the people.
I am, Your Honor. That is Thomas.
All right, Mr. Dineza,
May I proceed?
you may.
Everyone has a breaking point. We are here today because the defendant, Avery Becker, reached hers. And on March 6th, 2020, Ms. Becker broke into the home of Mackenzie Brackman in a struggle, stabbed, and killed him. My name is Thomas Dineza, and along with my co-counsel, we represent the people of the state of Colorado. First, let's meet Mackenzie Brackman, an attorney well known in the Denver community. Not only was he a respected member of the bar, but he also encouraged the next generation of lawyers by coaching the mock trial team at Colorado High School. And one of the best up-and-coming lawyers on the team, Avery Becker. Although the defendant will tell you how she cherished mock trial, her peers, Alex Cifuentes and Taylor Perkins, will tell you how her lazy attitude fractured her relationship with Coach Brackman. And Coach Brackman called the defendant out on this lack of commitment before the whole team just after the regional tournament last year. The rift between them exploded. Following this confrontation, you'll hear how seething with rage, the defendant sprinted out of practice with a Sharpie in hand and vandalized Coach's vintage Porsche 911. Understandably, Coach Brackman kicked the defendant off the team Immediately after that, the defendant herself will tell you how she went home and sobbed to her mother, saying, quote, she would get back at Coach Brackman if it were the last thing she did. The defendant repeated this threat to her mock trial teammate, Alex Cifuentes, who will also tell you about the text message he received from the defendant shortly thereafter, threatening Coach Brackman, claiming that she would get revenge against the coach by waiting until he was at work, breaking into his home, and trashing it. And on March 6th, 2020, the evidence will show that the defendant did just that and more. Because as it turned out, Coach Brackman wasn't at work. He was home. Detective Jordan Markowitz of the Denver Police Department will tell you that Coach Brackman's Ring doorbell alerted him of an intruder prowling outside of his residence. So Coach armed himself with a knife, only to lose this knife and his life in an altercation with the defendant. Detective Markowitz will explain how he collected electronic evidence, not only from the Ring doorbell system, but also from the defendant's cell phone. His analysis of the defendant's call records and location data from March 6th demonstrates the defendant's movements away from school, away from her house, and towards Coach Brackman's home right before the murder. Now, the defendant will try to explain away her movements that day by claiming to have lost her phone and that someone must have taken the phone. But the defendant only has one person who can corroborate this claim: her best friend, Taylor Perkins. The same Taylor Perkins who will tell you how he ditched school on March 6th just to allegedly help the defendant find her phone, and who got together with the defendant not once, but 2 times after the death of Coach Brackman, before either was interviewed by the Denver Police Department. Now, although the defense's expert, Professor Blake Van Owen, who, mind you, never visited the scene of the crime, will try to paint a picture that the intruder startled Coach Brackman and stabbed him while he was seated. These pieces just don't fit the puzzle that Kyle Kuzak, a crime scene reconstructionist for the Denver Police Department, solved. Investigator Kuzak will connect each piece of evidence Detective Markowitz collected: the scuff marks by the door, the shattered plate, the open drawer, along with the coroner's report detailing the knife angle to conclude the defendant was stabbed. The defendant stabbed Coach Brackman in a bear hug fashion following a struggle. The people have charged Avery Becker with second-degree burglary and first-degree murder. You may have heard this combination of crimes called the felony murder rule. This means that when the defendant killed Coach Brackman during the break-in, the defendant can be found guilty not only of breaking into the residence, but also murder. Following this trial, you will hear jury instruction number 8. The defendant need not have any intent to murder Coach Brackman, but simply the intent to commit a crime after knowingly breaking into his home. The evidence will show this intent beyond a reasonable doubt. Avery Becker had reached her breaking point. At the close of the trial, we ask that you find Avery Becker guilty of all charges. Thank you.
Thank you, Mr. Dineza. Opening statement for the defense, please.
Yes, Your Honor. May I begin?
You may, Ms. Donda. Thank you.
Alex Cifuentes had a dream and a plan. Alex spent hours preparing for mock trial, perfecting crosses and directs, and rereading and analyzing the case year after year. But Alex was still no match to Avery Becker. Avery was quick on her feet, intelligent, and a natural mock trial star. The only way Alex could stop Avery Becker would be to lock her behind bars. Members of the jury, this is a case about jealousy, a case about rivalry, and a case about a school dispute between Alex Cifuentes and Avery Becker taken too far. Alex Cifuentes convinced Alex's friend Blair Rollins to first work together to murder Mackenzie Brackman in cold blood, and then to frame Avery Becker for their malicious crime. Alex wanted to get Avery out of the way so that Alex could be a mock trial star, while Blair Rollins wanted to avenge Blair's father's incarceration. The burden in this case is on the prosecution. The prosecution must prove beyond a reasonable doubt that Avery Becker committed first-degree murder or second-degree burglary. As you listen to the evidence presented today, ask yourself 3 questions. First, how reliable was the murder investigation in this case? Second, where was Avery Becker on the day of Mackenzie Brackman's murder? And third, are there other suspects who might have had a motive and plan to kill Coach Brackman? To answer these questions, the defense will provide 3 witnesses: Blake Van Owen, Taylor Perkins, and Avery Becker. You will first hear from Blake Van Owen, a private investigator who reviewed the police investigation. She will explain that the prosecution's homicide detective, Jordan Markowitz, conducted a rushed investigation and never even considered other possible suspects in this case. Ms. Van Owen will explain the many deficiencies in the detective's investigation, the conclusions about the murder weapon, and the conclusions about cell tower data and Avery Becker's phone. You will next hear from Taylor Perkins, the defendant's best friend. Mr. Perkins will testify that he was with Avery Becker all day on the day of Coach Brackman's murder. He will testify that he and Avery were looking for Avery's lost phone and that they were nowhere near Mackenzie Brackman's house. Mr. Perkins will further testify that the last time he saw Avery's phone was when he and Avery were with Alex Cifuentes at the Fry Shack. And finally, Mr. Perkins will explain how jealous Alex was of Avery Becker's natural mock trial abilities. Finally, you will hear from Avery Becker, the defendant. Ms. Becker will testify that Alex was jealous of her mock trial abilities and that she and Alex were never even friends. She will further testify that she was with Taylor Perkins on the day of the murder looking for her lost phone. She will tell you that she never could have sent certain text messages from her phone because she didn't have it with her. And finally, she will explain her belief that Alex Cifuentes took her phone so that Alex and Blair could set it up to look like Avery had gone to damage Coach Brackman's house. After you hear from these witnesses, the evidence presented will demonstrate that the prosecution has failed to show beyond a reasonable doubt that Avery Becker committed this crime. The evidence presented will conclude that there is no physical evidence connecting Avery Becker to the scene of the crime. In fact, the testimony will demonstrate that Avery Becker was not at the scene of the crime, but rather with Taylor Perkins looking for Avery's lost phone. Finally, the evidence will demonstrate that Alex Cifuentes worked with Blair Rollins to frame Avery so that Alex could fulfill Alex's mock trial dreams. Alex Cifuentes had a dream and a plan, a dream to be a mock trial star, and a plan to convince Blair Rollins to murder Mackenzie Brackman and frame Avery Becker. Thank you.
Thank you, Ms. Donda. All right, I'm going to keep my promise. We're going to give the judges just a few moments to make notes, and then we'll start with the first witness. All right, the people can call their first witness, please.
The people call Detective Markowitz to the stand.
All right, Detective, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to offer in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. Please introduce yourself to the members of the panel and spell your last name.
My name is Jordan Markowitz, Markowitz.
May I proceed, Your Honor?
You certainly may.
What do you do for a living?
Well, I'm a homicide detective for the Denver Police Department.
How long have you been working there?
I've been working at the DPD for around 13 years, but I've been a detective for 7.
Do you have any other certifications?
Absolutely. I have a certification in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
I'm sorry, Your Honor, Miss Moraine got kicked out of the mock trial room. Can we pause time?
Absolutely.
there she
Let's
is.
pause. Let's still give her a few seconds to get her sea legs.
Thank you. I'm sorry to interrupt.
That's okay. We appreciate it. All right. So I tell you what, we will give time accordingly. And Ms. Seaman, go back with your initial question about training and experience.
Yes, Your Honor. Now, what do you do for a living, Detective Mark?
I'm a homicide detective for the Denver Police Department.
How long have you been working there?
Around 13 years, but I've been a detective for 7.
Do you have any other certifications?
I do. I'm certified in cell phone technology and forensic data reconstruction, and I received this at the American Academy of Law Enforcement.
And how did you obtain this?
I took a 3-day training course and then completed a high-level certification test.
Have you used this experience before?
I have. I've used the Cellubrite system software and call detail records in over 50 cases of detective work.
How are you involved in the case today?
I was the leading homicide detective.
Were you asked to give an expert opinion?
Yes, I was.
Your Honor, the people offered Detective Markowitz as an expert witness in the field of crime scene investigation, cell phone technology, and forensic data recovery.
Crime scene investigation, cell phone technology, and forensic data recovery.
Yes, Your Honor.
Any objections or voir dire by the defense?
Yes, Your Honor. May I please do a voir dire of the
You
witness?
certainly may. Yes, Ms. Murray, go ahead.
Detective Markowitz, you just testified that you have formal training in cell phone analysis, correct?
Yes, ma'am, that is correct.
In fact, you've done a number of specialized trainings in cell phone data analysis, right?
I believe I only had the 3-day training course in cell phone technology and forensic data recovery.
But you don't have any special certification in the area of crime scene reconstruction, do you?
Crime scene reconstruction, no, but I have 7 years of experience as a homicide detective, and the reconstruction part of that is intuitive to my job.
You also don't have any specific training or education in the area of crime scene reconstruction.
No, that is true. However, to become a homicide detective, there is a high level of training that is required.
You also don't have any formal certification or training in the area of crime scene analysis, isn't that right?
Yes, that is true.
For example, in this specific case, you have no specialized training in blood splatter analysis, do you?
Blood spatter, no, but again, I've been to hundreds of scenes in my 7 years as a homicide detective, and I've seen blood spatter numerous times.
Your Honor, based on the witnesses' responses and their admission that they do not have any certification, any formal education, or training in crime scene reconstruction or crime scene analysis, and the fact that their experience as a homicide detective does not immediately translate to expertise in crime scene analysis or reconstruction, I respectfully request that this witness be limited to giving expert testimony only in the area of cell phone analysis.
All right, let me hear from Ms. Seaman.
Yes, Your Honor. In accordance with Rule 702, an expert may express knowledge, skill, experience, training, or education. Detective Markowitz has the experience as a crime scene investigator and being a leading homicide detective for 8 years to be able to testify on crime scene investigation, crime scene analysis, and everything in this field to be able to testify on that in today's case because of that experience.
Very briefly, last word, Ms. Moraine.
Your Honor, Detective Markowitz's experience as a homicide detective does not immediately qualify him, and it does not translate to his expertise in the areas of crime scene reconstruction or crime scene analysis, as these two areas require specific and formal training beyond that which is gained as a homicide detective.
All right, The objection is well taken, well argued, but I'm going to overrule it. It's my view that the court has to act as a gatekeeper in a broad sense, but beyond that, the determination of the extent of the witnesses, I mean, I can define the extent of expertise, but the scope is going to be decided by the jurors. So I am going to admit this witness as an expert in crime scene investigation, cell phone technology, and forensic data recovery. Thank you for your good objections. Go ahead.
Detective Markowitz, you mentioned an expert opinion. What is that?
I did. So in this case, it is my expert opinion that the defendant, Avery Becker, went to Mr. Brackman's house on March 6th in 2020 and killed Mr. Brackman.
Now let's talk about how you reached that. How did you first become involved in this case?
Well, on March 6, 2020, a passing motorist, no name, reported a possibly passed out body on the porch of 444 South Flower Street.
What did you observe when you got to the house?
I observed that Mr. Brackman's body was just inside of the house, just inside the front door, which I thought was odd because the passing motorist reported the body to be on the porch.
Did you review the body's position?
I did, yes.
Please turn your attention to Exhibit 2. Can you please explain what this is?
Yes, this is a picture of Mr. Brackman's body, the location of it within the household. The stab wound is visible, as well as a pool of blood just under his left shoulder.
Is this a fair and accurate depiction of the way you saw the body?
Yes, it is.
Your Honor, the people offer Exhibit 2.
Any objection to this? And how's this Exhibit 2? Is this coming in as Exhibit 2?
Yes, Your Honor.
All right. Any objection to Exhibit 2?
Yes, Your Honor. The prejudicial value of Exhibit 2 outweighs its probative value, as while it's very likely to prejudice the jury, its probative value is low since Detective Markowitz has already explained the location of the body, and it is therefore unlikely to further the jury's understanding of the case in any substantial way.
All right, Ms. Seaman, why isn't 403 applicable?
403 probative value is farly outweighing any prejudice. It's showing the angle of the body, and Detective Markowitz, I assume, will tell you in a little bit that the position of the body shows how Mr. Brackman collapsed on his way to escape the door, and therefore showing the angle and the way in which he collapsed has far more probative value than the prejudice of showing blood on the screen. And the argument goes more to the weight of the testimony rather than its admissibility.
All right. Ms. Moraine, last word briefly.
Your Honor, Detective Markowitz, as Ms. Seaman just said, is going to extensively explain the angle by which Detective Markowitz fell, but the angle by which Mackenzie Brackman fell and was stabbed. And therefore, it's not necessary that this exhibit is published to the jury, as it is very likely to prejudice them, considering that it shows graphically an image of Mr. Brackman dead on the floor.
All right. Thank you for your good arguments. The objection will be overruled. Given the relevance of this evidence, I don't think that the prejudice is sufficient. So I do agree with Ms. Seaman that it goes more to weight than admissibility. So the objection's well-founded but overruled.
Detective Markowitz, what could you determine based on the position of the body?
Well, I determined that Mr. Brackman was stabbed somewhere within the interior of the house, and then tried to flee the scene via the front door. However, he collapsed face down in a pool of blood.
Did you observe a weapon of attack?
I did. There was a large chef's knife next to the victim's body.
After viewing the body, where did you go?
I walked around the exterior of Mr. Brackman's home.
What did you see there?
Well, here I observed 3 different Ring doorbell security cameras.
Did you investigate the footage from those cameras?
I did. I used the Cellubrite system software to download the contents of Mr. Brackman's phone. Here I found 4 different videos that related to Mr. Brackman's murder on the day of March 6th, 2020.
Now please turn your attention to Exhibit 12. Can you explain what this video is?
Yes. As we can see, the perpetrator is opening the door and waltzing in the house, closing it behind him, obviously making a fair amount of noise.
Is this a fair and accurate depiction of the video you reviewed in the case?
It is, yes.
Your Honor, the people offer Exhibit 12.
Any objection to 12?
No objection to Exhibit 12, Your Honor.
All right, 12 will be admitted. Thank you.
Can you please explain what stands out to you from this video?
Yes, again, the perpetrator is just waltzing in the home and closing it shut, obviously creating a commotion and fair amount of noise.
After viewing videos, where did you go?
Next, I entered through the same back door and into the living room of Mr. Brackman's house.
What did you see there?
Here, as in the living room, I noticed a scene that was in slight disarray. There was a broken plate on the floor, a toppled over chair, and then in the kitchen, there was an open knife drawer and a missing slot in the nearby knife block.
Was there blood at the crime scene?
There were blood droplets leading from the kitchen/living room area to Mr. Brackman's body.
And after reviewing all of the evidence at the crime scene, what could you conclude?
Well, I concluded that Mr. Brackman was likely alerted of the intruder's presence, either from the Ring doorbell security system or from the intruder opening the door. Mr. Brackman then armed himself with a large knife and confronted the intruder. The intruder and Mr. Brackman then got in some sort of scuffle. The intruder gained a hold of this knife, stabbed Mr. Brackman. Mr. Brackman then tried to flee the scene via the front door. However, he was unable to and collapsed face down in a pool of blood.
Now let's talk about the rest of your investigation. What did you look into next?
Well, next, I turned to the evidence, as I always do, and I went to Mr. Brackman's phone, where I found copious numbers of emails and text messages that related to Mr. Brackman's work and mock trial.
Did you investigate this any further?
I did. I discovered that Mr. Brackman was the coach of the Colorado High School mock trial team.
Did you contact any students?
I did. I obtained a list of all the students that Mr. Brackman coached, and I contacted the first student on that list, Mr. Alex Cifuentes.
What did you learn from Mr. Cifuentes?
I learned about a possible threat to break in and trash Mr. Brackman's house.
Do you know who this threat came from?
Yes, this threat came from Avery Becker.
And do you know how this conversation took place?
Yes, it was via text messaging.
Did you receive copies of these text messages?
I did. Upon interviewing Alex Cifuentes, I asked him to send me screenshots of the text message that occurred between the two individuals.
Please turn your attention to Exhibit 14. What is this?
This is the text message that I received from Alex Cifuentes.
This is a fair and accurate depiction of the text messages you received?
It is, yes.
Your Honor, the people offer Exhibit 14.
Any objection to 14?
Yes, Your Honor, I object to the admittance of Exhibit 14 on several grounds.
Okay.
Firstly, Exhibit 14 is hearsay under Rule 801 because Exhibit 14 calls for an out-of-court statement. Secondly, under Rule 1003, the admissibility of duplicates, this duplicate is not admissible as a genuine question has been raised as to the original's authenticity. And I also object under Rule 901, which details that exhibits must first be authenticated before they are admitted, and the authenticity of Exhibit 14 was never confirmed.
All right. So, Ms. Seaman, let's hear first on the hearsay.
Yes, Your Honor. In response to the statements made by Avery Becker in this case, they are not hearsay under Rule 801D2 as they are an admission by the party opponent. In response to the hearsay of Mr. Cifuentes' statements in this case, they are also not hearsay under Rule 801C2 as they are not going to the truth of the matter asserted, rather to show the effect on the listener or the reader, in this case, Avery Becker.
Okay. And then what about the other bases for objection?
Yes, Your Honor. In response to the 1003 objection, duplicates are admissible. In response to the authenticity objection, under Rule 901B1, a piece of evidence may be authenticated if a witness with knowledge can authenticate it. Detective Markowitz, in this case, interviewed Mr. Cifuentes. He received copies of these screenshots and therefore is a witness with knowledge and can authenticate this document, making it admissible under Rule 1003.
How about 901?
Yes, Your Honor. 901B1, a witness with knowledge can authenticate a document.
All right, thank you. All right, let's hear again from Ms. Moran briefly.
Your Honor, Rule 803.1 hearsay applies to statements of, Rule 801D. It has not been verified that Avery Becker sent these text messages, and they therefore do not constitute an admission by a party opponent. For Rule 1004, it does not apply to Exhibit 14. Unlike Ms. Seaman said, because there is a genuine question as to whether the proponent, Alex Cifuentes, was acting in bad faith, and there is a genuine question as to the original's authenticity. As to Rule 901, it does not detail that a witness with knowledge can authenticate an exhibit, but rather an exhibit must be authenticated by the person who the person who created the text messages in this scenario, which Detective Markowitz did not.
Can I respond briefly, Your Honor?
No. The objection, first of all, I don't find it to be hearsay because I don't think it's an out-of-court statement offered to prove the truth of the matter asserted. So I'm not going to deal with the 801 concern. And then with respect to 901, 1003, I find that I'm just going to let it in and decide that it goes to weight rather than admissibility. So the objection, while well-founded, is overruled.
Detective Markowitz, what stood out to you from these text messages?
Well, specifically, you can see Alex Cifuentes asked, "What are you going to do to his house?" He's asking Avery Becker. And then Avery Becker responds, "I'm going to wait until he's at work, then break in and trash it."
Now, after reviewing these text messages, what did you do?
Well, next, I obtained a court order for Avery Becker's account detail records for her cell phone.
And did you review these records?
I did, yes.
And was a map made of these call detail records?
Yes,
Please turn your attention to Exhibit 15. Is this that map?
it is, yes.
And are you familiar with this area?
I am, yes.
Are you familiar with the cell towers in this area?
Indeed, I am.
Your Honor, and is this a fair and accurate depiction of the map you reviewed in this case?
Absolutely.
Your Honor, the people offer Exhibit 15.
All right. Any objection to Exhibit 15?
No objection, Your Honor.
All right. 15 comes in as well.
Detective Markowitz, can you please explain what call detail records are?
Yes. So call detail records allow you to determine the location of an individual's phone based off when that phone connects to a cell tower, specifically a cell tower antenna.
And could you determine Ms. Becker's location based on these records?
I could determine a possible route that I thought Ms. Becker took on the day of March 6th in 2020 to Mr. Brackman's home.
Before you show us that route, can you identify Ms. Becker and Mr. Brackman's home on this map?
Absolutely. Ms. Becker's home is in the top of the screen. Mr. Brackman's home is in the bottom left corner of the screen.
And based on these records, what probable route do you think Ms. Becker could have taken?
Well, the route that I found most probable is as follows.
And how does this route correlate with the time of death?
Ms. Becker placed several texts and phone calls on the day of Mr. Brackman's murder, and each of these phone calls and texts correlated with a specific cell phone tower antenna and at specific times. And these times are outlined in blue.
How do those times correlate with the murder?
Well, those timestamps represent when Ms. Becker was within the different degrees of gradation, the gradation of the cell phone tower antenna. That is the red represents this gradation. And it plants these, so Ms. Becker's phone was within the range of these cell towers during each individual timestamp.
Your Honor, the people offer Exhibit 15A as a demonstrative exhibit for the jury.
Is there an objection to 15A coming in?
No objection, Your Honor.
All right, 15A will come in as well. It's admitted.
Detective Markowitz, after reviewing all this information, what was your final opinion in this case?
Well, it is my opinion that Avery Becker, the defendant in this trial, went to Mr. Brackman's house on March 6, 2020, and killed Mr. Brackman. She reached her breaking point.
No further questions, Your Honor.
Thank you, Ms. Moore. All right, so tell you what, we will just go through and then take a brief moment for the judges. Cross-examination, please.
Good afternoon, Detective Markowitz. My name is Olivia Moraine, and I'm just going to ask you a few questions.
Absolutely, ma'am.
You arrived at the scene of the murder and noticed a body just inside the front door, right?
At 2:20 p.m. in the afternoon, yes.
And after confirming their ID, you recognized this person, didn't you?
I did. I'd recognized Mr. Brackman as a criminal defense lawyer. I've worked with Mr. Brackman in a multitude of different cases.
So upon realizing the body was Mackenzie Brackman, you thought it possible that he was killed by a, quote, disgruntled ex-client. Is that right?
Well, it certainly raised the specter before I proceeded to go through all of the evidence in this trial.
So you never followed up on this theory, did you?
No, because the evidence pointed me to the defendant in this case, Avery Becker.
You instead formed your opinion based on what you deemed the, quote, first big break in the case, right?
The evidence that was in this case, the cold hard evidence, showed me that the defendant, Avery Becker, killed Mr. Brackman.
Detective Markowitz, that's not what I'm asking. I'm asking if you formed your opinion based on what you deemed the first big break in the case.
No, I did not. I formed my opinion based on the evidence that I looked at within this case.
Do you recall saying in your witness statement that you formed your opinion based on what you deemed the first big break in the case?
Objection, Your Honor. Improper impeachment.
And improper how?
She is using an out-of-court statement, Mr. Detective Markowitz's statement, to impeach him right now without actually going through the steps and making sure that he has seen this record before.
All right. Ms. Moraine, thank you. Ms. Moraine, I'll just give you a chance to ask questions again.
Your Honor, it's all right. I'll move on.
Thank you.
Detective Markowitz, you use forensic software to download the contents of Mackenzie Brackman's phone, right?
I use the Cellubrite system software. This allows me to download contents of individuals' phone, yes.
So this technology that has the capacity to download the contents of an individual's phone was available to you throughout the course of this investigation, wasn't it?
It was, yes.
But you didn't use this technology to examine the contents of Alex Cifuentes' phone, did you?
Alex Cifuentes got rid of his phone. I believe he stated that he had a faulty battery. Excuse me?
Is that a no?
No, I never downloaded the contents of Mr. Cifuentes' phone in this case.
Please direct your attention to what's been previously admitted as Exhibit 14. Are you familiar with Exhibit 14?
Yes.
And you said you received these, what appear to be screenshots of text messages from Alex Cifuentes, right?
Yes, I told Mr. Cifuentes after we conducted our interview to send me these screenshots.
But you never saw these text messages directly, did you?
No, he left his phone at home. I had to request that he send them to me.
So you accepted these images from Cifuentes a day after your interview, right?
Yes.
And you didn't ever actually confirm the validity of these text messages, did you?
No, and that is because the call detail records of Avery Becker's phone confirmed the validity of these text messages because it placed her at the scene of Mackenzie Brackman's death.
Yes, but Detective Markowitz, you used these text messages, which you have just confirmed were unverified evidence, to form your theory against Avery Becker, didn't you?
Yes, and this was after I confirmed her
I would now like to
location
direct
via
your
call
attention.
detail records.
I would now like to direct your attention to the part of your investigation that focused on those call detail records. You reached out to Avery's attorney to obtain a warrant to search the phone of Avery Becker, correct?
Yes, this is true.
But you were told this was impossible because Becker lost the phone on March 5th, correct?
Yes, this is true. However, I would also like to point out that
Detective
all of the
Markowitz,
communications from Ms. Becker's phone
Detective?
ceased.
Go ahead, counsel, with your next question.
So while you conducted your analysis, you knew that it was possible that Avery had lost their phone, correct?
Yes.
Yet from this point on in your statement, you refer to the position of the phone as the position of Avery, isn't that right?
That is true. That is what I believe to be the case.
But Avery and her phone are actually two different things, aren't they?
This is true, yes. However, I disagree with the premise of that question.
But you just assumed Avery and her phone to be the same entity, didn't you?
I did not assume. The text messages that I received from Mr. Alex Cifuentes placed her with her phone. That was a corroboration together. And then based on my call detail record analysis, I could pinpoint Ms. Becker's tracking location from her phone to Mr. Brackman's house.
Yes, but that's not my question. My question is that you have no way of confirming that Avery was in possession of the phone on March 6th during the time of the cell phone records.
No, I do not.
Let's move on to the various calls and texts between the phone of Becker and the phone of Perkins. Your CDRs confirmed that there was cell communication between the phone of Becker and the phone of Perkins, right?
Yes, there were a multitude of calls and text messages placed between the two individuals.
And the duration of these calls were so short that there was likely no connection between Avery's phone and Taylor's phone?
Well, considering what the defendant Avery Becker was doing at the time, I'm not surprised that there was.
So, yes.
Yes.
So short that there was likely no connection. In other words, Avery didn't pick up the phone, right?
This is true.
But you don't know why she didn't pick up the phone, do you?
Well, given the fact that I believe Avery Becker murdered Mr. Brackman, I believe that you cannot pick up a cell phone when you are murdering someone.
But it's possible that Avery didn't pick up the phone because she didn't have the phone, isn't it?
If that were to be the circumstance, yes, that would be possible.
Thank you, Detective Markowitz. Your Honor, I have no further questions.
All right. Ms. Seaman, redirect, please.
Excuse me. Yes, Your Honor. Who do you believe had Avery Becker's phone on March 6th?
Avery Becker.
No further questions, Your Honor.
All right, thank you. All right, let's take a moment for the judges. All right. Next witness, please.
Yes, Your Honor. The people call Alex Cifuentes.
Mr. Cifuentes, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to offer in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. Please introduce yourself to the jury and spell your last name, if you would.
Hi, my name is Alex Cifuentes, Sifuentes.
Mr. Cifuentes, do you currently go to high school?
Yes, I'm currently a senior at Colorado High School.
And do you know the defendant, Avery Becker?
Yeah, me and Avery, we were friends, and we were even on the mock trial team together.
And did you know Mackenzie Brackman?
Yes, Coach B was my mock trial coach.
Now, based on your personal observations, what was the relationship like between Avery Becker and Coach Brackman?
Oh,
I'm
it
sorry,
was
Mr.
horrible
Cifuentes,
to
cut
say the
out.
least. It was horrible to say the least. I mean, it was like Batman and the Joker. Coach Brackman would criticize Avery for one thing or another, and Avery would never take that criticism well.
Did Coach Brackman ever punish Miss Becker?
Yes, Avery was actually demoted to the B team, which it made Avery pretty upset. I mean, no one puts Avery on the B team.
And what happened next?
Avery's other friend, Taylor Perkins, quit the A team, so that way Avery can make it back on in time for regionals.
And how did the team end up doing at regionals?
We did fantastic. I mean, we secured our spot at state, even though it was canceled because of COVID. Avery even won a couple of awards.
And did that seem to help their relationship?
Not at all. I mean, if anything, it got worse. Coach Brackman, I respected him.
Isolation.
Ms. Dino?
Yes, Your Honor. Your Honor, the witness is testifying to what he personally observed in this mock trial practice. He was at the mock trial practice present after the regional tournament. Therefore, he can testify to what he saw between the interactions of Ms. Becker and Coach Brackman. Therefore, he does not have to speculate to answer this question.
All right. I'm going to overrule the objection.
So, Mr. Cifuentes, from what you saw, did that seem to help their relationship?
No. And if anything, it got worse. And I respected Coach Brackman a lot, but he says some pretty nasty things to Avery. And it was like, Houston, we have a problem. That's how bad things would get sometimes.
And how did Ms. Becker react from what you saw?
No. Avery became infuriated, and she had hit her breaking point. And it was like that shootout scene from the movie Point Break, where all heck breaks loose. And Avery took a Sharpie and stormed out of the classroom all fast and furious. And on her way out, she wrote Worst Attorney Award all over Coach's Porsche 911.
Objection, unfair prejudice.
That's a Rule 403 objection?
Yes, Your Honor.
All right. Do you find that is there any relevance to it? Ms. Donda?
Oh, I'm sorry. Under Rule 403, this testimony is unfairly prejudicial and it outweighs the probative value.
I see. Okay. Thank you. Ms. Dina?
Yes, Your Honor. The witness is just testifying to exactly what he saw the day of this occurrence. He saw Ms. Becker grab the Sharpie marker and he saw her go outside and vandalize Coach's car. He's not explaining this with any prejudice. He is explaining the actual facts of what happened that date.
Oh, all right. Ms. Donda, I get you the last word.
Your Honor, I stand by my objection. This certainly is unfairly prejudicial.
I think it is prejudicial, but that's part of what we do. I don't find that it's unfairly prejudicial, so the objection will be overruled.
So, Mr. Cifuentes, after the vandalization, can you explain what kind of marker she used and how you knew that?
Oh, first of all, we keep our Sharpies on an easel of paper where we write our trial notes down on. And secondly, I mean, come on, a Sharpie, a dry erase marker, they do not look identical.
And do you know if the defendant had any sort of punishment to this action?
Oh yeah, Avery was kicked off the A team and she wasn't going to get back on.
And after the vandalism incident, did you hear from Ms. Becker?
Yes, Avery texted me asking if I'd talk to Coach on her behalf.
And did you?
Yes, I did.
And what happened when you talked to him?
I talked to Coach and Coach said he wasn't going to back down.
How did Ms. Becker react when you told her this?
Oh. Avery became infuriated again. It was like she hit her breaking point again.
Objection, speculation.
Ms. Dina?
Yes, Your Honor. Mr. Cifuentes is testifying to what he observed and what Ms. Becker said to him. This is based on his rationally based opinion. So he knows how she reacted because she sent it in text messages to him.
All right. Well, then all right. So, Ms. Donda, do you have a further objection?
Well, Your Honor, Mr. Cifuentes cannot accurately testify to the emotional state of Ms. Becker as he does not have personal knowledge under Rule 602.
All right. The objection is sustained. It is either speculation or hearsay, but in either event, it's inadmissible.
Your Honor, permission to share Exhibit 14, it has been previously admitted.
Absolutely.
So after you said you doubt anyone could change the coach's mind, what did the defendant say?
Avery said, well, if he's still going to be upset about his car, then he's going to be really upset when he sees what I do to his house. And that had me all dazed and confused. And I asked her, what are you going to do to his house?
And what did she say to that?
Avery said that she was going to wait until Coach was at work and then break in and trash the place. That'll show him.
Thank you, Mr. Cifuentes. So after Coach Brackman was murdered, did the police ever contact you?
Yes, I was contacted by Detective Markowitz and we talked on the phone, and then he asked me to come in for a full interview. And then I went down to the police station thereafter.
Did Detective Markowitz ever see these texts in Exhibit 14?
Yes, he did. I sent him exact screenshots because I'd left my phone at home on the charger because it wouldn't hold a charge anymore.
So I want to ask about the Fry Shack on March 5th. Were you there that day?
Of course. There's no place like the Fry Shack.
And who did you see there?
Oh, Avery and Taylor were both there, and so were the usual suspects, the whole mock trial team.
Did you notice if the defendant had her phone with her?
Yeah, Avery definitely had her phone with her. She even let me play a new game on it.
Did you end up taking Miss Becker's phone?
No, I have my own phone.
So switching gears, let's talk about Blair Rollins. Did you know him?
I knew him of him. I would say hi to him once or twice in the hall, but that's about it.
And did you give the defendant's phone to Blair Rollins?
No, that's completely absurd.
Now, finally, you said that Miss Becker was a lawyer at mock trial. Was she also a witness?
Oh yeah, you could put Avery on the stand and she could sell you anything.
No further questions, Your Honor.
Thank you. Ms. Denda.
Good evening, Mr. Cifuentes. My name is Adele Donda, and I would like to ask you a few questions.
All right.
You testified that you and Avery were on the mock trial team at Colorado High School, correct?
Yes, we were on there together.
Avery was pretty good at mock trial, wasn't she?
Yeah, she would kind of skate by without preparing sometimes, but she still won the awards. An award for Avery is an award for all of us.
And you were pretty good too, weren't you?
Oh, I sure like to think I was, yeah.
But no matter how hard you tried, Avery was always better than you, wasn't she?
No, I prepared. I would say I prepared more than Avery, but Avery would show up to practice without preparing and still do good.
And that was frustrating for you, wasn't it? That Avery would do so well without trying.
Objection, Your Honor. This is improper character evidence.
What rule are you relying on, Ms. Dino?
Rule 404, Your Honor.
Ms. Denda?
Your Honor, this certainly is not improper character evidence, as I am not asking Mr. Cifuentes to speculate beyond his personal knowledge.
All right, Ms. Dino.
Your Honor, I am not objecting to speculation. I am objecting that the fact that the opposing counsel is trying to say that because Mr. Cifuentes would have been jealous or had some sort of vendetta against Ms. Becker after she got more awards, that he would act in conformity with that character on March 6th and today in court. Therefore, it is improper character evidence under Rule 404A1.
Your Honor, response.
No response. Hang on just a moment. I don't think this goes to character under 404A1. I think that it goes to other things, including credibility, bias, and prejudice. So I'm going to overrule the objection under 404A.
Thank you, Your Honor. May I repeat the question?
You may. Please do.
No matter how hard you tried, it was frustrating for you that Avery would do so well without trying, wasn't it?
Oh, I'd say it irked me sometimes. I thought I prepared a lot, but the scoring panelists like Avery's way of doing things.
Thank you. So you'd admit you were a little jealous of Avery.
I'd say personally I was a little bit.
And in fact, you were so jealous that you even thought Coach Brackman should have pressed criminal charges against Avery.
No, that's not coming from jealousy. That's not coming from jealousy. She vandalized Coach's car. And that car is so nice. I wish I had a car like that.
Now, moving on, please direct your attention to previously admitted Exhibit 14. Exhibit 14 is a screenshot you said you took of text on your phone, correct?
Yes, they are.
But when you met with the detective, you didn't bring your phone, did you?
No, like I said, I had left it at home by accident on the charger.
So instead you sent screenshots of your phone to the detective, correct?
Yes, which the detective said were perfectly acceptable.
So you're the only one who saw the text messages in Exhibit 14 on your actual phone, correct?
Detective Markowitz saw the exact text. I don't even have my phone anymore, so I don't even know where my phone is because I got a new one.
Thank you. And if you could just answer yes or no to the following questions, that would be great. So,
Objection, Your Honor.
I'm sorry.
Objection, Your Honor. That statement was not in the form of a question. I asked that opposing counsel does not address my witness directly.
Overruled.
thank you, Your Honor. Now, going back to the questions. When you met with the detective, you did not bring your phone, did you?
No, like I said, it was at home on the charger and I've forgotten it.
So instead, you sent screenshots of your phone to the detective.
Yes, I did.
And you're the only one who saw those text messages in Exhibit 14 on your actual phone.
Objection, Your Honor. This question has been asked and answered.
Ms. Donda?
I'm sorry, Your Honor. I will proceed to the following question.
All right. The objection sustained, Ms. Dino.
You testified that you do not have your phone anymore, didn't you?
Oh, yeah, that's just the facts, man.
You couldn't even show me the text on your phone right now then, because you conveniently got rid of the phone, correct?
It wasn't conveniently that I got rid of my phone. I mean, I needed a new phone because it wouldn't hold a charge anymore. And that's why I have a new phone. And I haven't seen my old phone in quite a while.
So we really can't confirm that Exhibit 14 is an actual screenshot then, can we?
Well, you definitely can. I mean, it's right in front of us. It's Exhibit 14.
Okay, so let's assume for a minute that these really are actual screenshots from your phone. Could you look at the top of the screenshot and tell me, is there a time on that screenshot?
Yes, there is a time on that screenshot.
And that's the time you took the screenshot right before you sent it to the detective, right? I
believe so.
But there's no time indication on the individual text between you and Avery, is there?
There's that that timestamp right there in the upper left corner. I think that goes.
Mr. Cifuentes, as you stated earlier, that is the time that you took the screenshot.
Yes.
So please answer the question that I asked. There is no time indication on the individual texts between you and Avery.
No, it does not appear so, but I'm not really sure when timestamps would show up for individual texts.
Thank you. So we really don't know when those texts were sent, do we?
Well, they were sent between me and Avery, and that's when Avery told me that she was going to break into Coach's house and trash the place.
Thank you. And is there a date indicating the day the texts were sent?
Again, I do not see it on Exhibit 14.
So these texts could have been sent before or after the murder of Mackenzie Brackman?
They were definitely sent before, because this is Avery telling me that she's going to break into Coach's house. And that's what she did, and that's how Coach Brackman ended up dead.
And we also don't know if you created those texts or if Avery sent them then, do we?
I do know that Avery sent those to me. Also, I did text these with her. So, I mean, I feel like I'm an honest person. If you're trying to say I'm not, then just call me out.
Now, moving on, let's go back to the day you saw Avery and Taylor at the Fry Shack after Avery got kicked off the team. You and Avery had a good talk that day, didn't you?
Yeah, I'd say so. We talked about how she could move on.
Thank you. And Avery even let you play a game on her phone, didn't she?
Yeah, I mean, it's a pretty fun game.
So tell me again, you did have Avery's phone that day at the Fry Shack?
Yes, I did have Avery's phone.
Thank you, Your Honor. I have no further questions.
Thank you. All right, Ms. Dino, redirect, please.
No redirect, Your Honor.
Thank you. All right. May this witness be excused. All right, thank you, Mr. Cifuentes. We appreciate your testimony. We're going to give the judges a few more moments.
Thank you, Your Honor.
Thank you, sir. All right, next witness, please.
Your Honor, the people call Mr. Kyle Kuzak. Before I begin, may I request a brief time check as well?
It's a great idea. Timers?
There's 9 minutes and 31 seconds remaining in P direct.
Thank you.
All right. All right, Mr. Dinezza, whenever you're ready. Thank you, Mr. Carr.
Mr. Kuzak, please introduce yourself to the jury.
Hi, my name is Kyle Kuzak, Kuzak.
All right, and you are hereby sworn. Do you swear?
Yes, Your Honor.
Thank you. Go ahead. Sorry about that.
Apologies, Your Honor. What do you do for a living, Mr. Kuzak?
Well, I'm a civil crime scene reconstructionist, currently working on loan from the Denver Police Department.
Now, crime scene reconstructionist. Could you explain to the jury what that means?
Well, crime scene reconstruction, we call it CSR for short. So earlier you heard the testimony of Detective Markowitz. He works on another side of the crime scene. He works on the investigation side with the forensics teams and trying to give me all the pieces that I can put together. I like to think of it like a puzzle. Now, what makes me a puzzle master and what makes these puzzles so hard is that we don't have the picture on the back of the box of most puzzles. So I have to put these pieces together blind. That's what makes me the expert.
Do you have any certification in this field?
Yes. So when I first started working as a CSR, I got board certified 19 years ago.
And what sorts of cases in your 19 years have you worked on?
Well, currently and for the last decade, I've been specializing in complex crime scenes. Now, that might be homicides, burglaries, armed robberies, break-ins, you name it.
For today, were you asked by the people to give an expert opinion?
I was, yes.
Did you reach any of those set opinions?
Yes, I did.
Your Honor, the people offer Mr. Kyle Kuzak as an expert in the field of crime scene reconstruction and investigation.
And investigation. All right, Ms. Davies, any objections or voir dire?
Yes, may I please complete a voir dire?
Absolutely.
And before I begin, can I please have a quick time check?
You have 6 minutes and 5 seconds left.
Thank you. Mr. Kuzak, you are not a police officer, isn't that correct?
No, ma'am, that is correct.
And you only have a certification in crime scene reconstruction.
Yes, from the Colorado Bureau of Investigation.
And you don't have an official degree in crime reconstruction.
No, when you're board certified, that's when you start practicing.
Your Honor, based on the witnesses' responses and their admission that they do not have a degree or education in crime scene reconstruction, they should not be qualified as an expert in crime scene reconstruction in this case.
If I may, Your Honor.
Mr. Dinezza, you may respond.
Your Honor, this witness meets the requirements of an expert witness under Rule 702. I've laid proper foundation to establish that Mr. Kuzak has the knowledge, skill, experience, education, or training to testify in the field of crime scene investigation and reconstruction. Mr. Kuzak just testified that he has training from the Colorado Bureau of Investigation, as well as having worked in the field for 19 years. Counsel's objection goes to the weight, not the admissibility.
Ms. Davies, last word.
I stand by my objection, Your Honor.
All right. All right. So under Rule 702, an expert can be deemed, a witness can be deemed to be an expert based on experience, skill, or education. Under Kumo Tire and that whole line of cases, experience is itself sufficient. So I do agree with counsel that this goes more to weight than admissibility. So the objection, while well-founded, is overruled.
Mr. Kuzak, you mentioned some expert opinions. What were they?
All right, and I'm sorry, pardon me, and I'm sorry to apologize. So this witness will be admitted as an expert in crime scene reconstruction and investigation.
Thank you, Your Honor. My apologies.
No, that's on me.
Mr. Kuzak, you mentioned some expert opinions. What were they?
Well, first, the defendant, Avery Becker, arrived at Mr. Brackman's residence, tried the front door, couldn't get in, moved around to the back, and got in. That's when the two met. And ultimately, she killed Mr. Brackman.
Now, let's talk about how you reached that conclusion. How did you first become involved in the case?
Well, how I usually get involved was the same way I got involved with this case. I got a call from the head detective at the scene. In this case, it was Detective Markowitz saying, "We have a messy crime scene on our hands. We have a lot of puzzle pieces. We need your help."
Once on scene, how do you go about collecting evidence?
Well, I take a few pictures, and I did in this case, but mostly I try and get a macro level bird's eye view of the case so I can better understand what actually happened when I go into my steps in my linear sequential unmasking process.
You mentioned steps. What do you mean by this?
Well, as a CSR, I use a 5-step process that guides me from seeing the puzzle to completing the puzzle.
And could you explain these 5 steps for the jury?
Sure. So step 1 is my recognition and my documentation of evidence. It's kind of like going to Walmart and looking at the different puzzles on the wall. Steps 2 and steps 3 are my collection and my evaluation of that evidence. That's when I dump the puzzle out on the table, start sifting through the pieces and connecting easier pieces, maybe not the sky, which is always the same color, but I start to put the pieces together. Now, step 4 is my hypothesis and my testing. That's where we get into the details of what actually happened. We wedge in those difficult pieces and we look at the sky pieces that are all the same color. Now, this also involves peer review and testing. Step 5 is my ultimate crime scene reconstruction.
Now, let's walk through the occurrences of March 6th in light of this method. How did the perpetrator enter the residence?
Well, like I said earlier, the perpetrator first tried the front door, couldn't get in, so moved around to the back of the house where she entered through a glass door.
And how do you know this?
Well, there were videos taken of the crime scene, as well as black marks. In CSR, we call them scuff marks, just inside the door that indicate a struggle between the intruder and Mr. Brown.
Objection, relevance.
What's the relevance, Mr. Dinezza?
Of course, Your Honor. May I ask if counsel is objecting to the relevance of the scuff mark specifically, or how the perpetrator entered?
Yes, I'm objecting to the relevance of the scuff marks.
Of course. Your Honor, the definition of relevant evidence is any evidence that makes a fact more or less probable for today's case. The scuff marks make the fact that the perpetrator was met with force upon entering the residence more probable. Thus, this evidence is highly relevant for today's case.
Ms. Davies?
401.
These scuff marks could have been created at any time, and there's no way to tell when or how these scuff marks were created just because they were in the house.
All right. So the fact that the source of the scuff marks can't be determined absolutely doesn't make it less than relevant based on the definition of relevant evidence in Rule 401. So the objection's overruled.
Thank you, Your Honor. Mr. Cusack, what's notable about these scuff marks?
Well, as I said earlier, these scuff marks indicate some sort of scuffle, altercation, fight between the intruder, Ms. Becker, and the victim, in this case, Mr. Barackman. They met each other. The intruder was met with force, and the intruder responded with force.
Would you recognize an image of these scuff marks if shown to you?
Yes.
Permission to share Exhibit 18.
Permission's granted. You're going to share with whom?
This is being shared with the witness and effectively not seen by the jury. Although
Okay, good, with counsel. That permission's granted. Sorry to interrupt.
Thank you, Your Honor. What is this, Mr. Cusack?
Well, I actually took this image. These are those black marks on the ground made by shoes just inside the door that I was talking about.
And is this a fair and accurate representation of those scuff marks that you believe?
Yes.
Your Honor, at this time, the people move to enter Exhibit 18.
All right. Ms. Davies, what do you say about Exhibit 18?
Still, I object on relevance and also lack of authentication, but as my objection was overruled, no objection to this.
All right, so the prior evidence will be, the prior ruling will be affirmed, I guess. Go ahead, sir.
Your Honor, may be effectively published to the jury.
You may.
Thank you. Now, Mr. Cusack, is there any evidence other than these scuff marks that lead to us to believe there was a scuffle?
Well, absolutely. So there's a Ring doorbell notification that leads me to believe Mr. Brackman was not sitting at his counter or his table when the intruder walked inside. And And there's also a knocked over chair, and I found a broken plate on the ground at the scene.
Now, as this scuffle continued, how did it end?
Well, Ms. Becker got control of the knife from her coach, and ultimately, sadly, she stabbed her coach in the back.
And how exactly was Mr. Brackman stabbed?
Well, scientifically speaking, Mr. Brackman was stabbed in his lower left back, just inferior to his scapula. Now, the knife initially slightly pierced the pulmonary artery and significantly pierced the aorta, the largest artery in the body. Once the knife was inserted, it acted as somewhat of a plug, and maybe Mr. Brackman would have survived, except that Mr. Brackman decided to pull the knife out of his back in a frantic state, and he ultimately bled to death soon after.
Now, in light of the nature of the reconstruction, what can we conclude about the murder of Mackenzie Brackman?
Well, to me, it looked like a burglary gone wrong.
Thank you, Mr. Cusack. Let's move on to Professor Van Owen. Do you know Professor Van Owen?
I have the displeasure of knowing Miss Van Owen, yes.
How do you know Professor Van Owen?
I would love to refer to her as Miss Van Owen, as it gets under her skin. So she has shown up on some Zoom meetings before, maybe a conference or two, and she tries to show off all that she's done for the defense, and really, it's nothing.
Do you know of Professor Van Owen's specific CSR qualifications?
I don't know if Miss Van Owen has any CSR qualifications.
In your experience and using your expertise, how does it appear that Professor Van Owen goes about conducting their CSR investigations?
Well, as I mentioned earlier, what makes me a puzzle master is when I'm assembling these puzzle pieces, I don't have the picture of the completed puzzle on the back of that box. Now, to me, Miss Van Owen tries to find a picture that she believes the puzzle will fit, and then just jams the pieces together in hopes that they will match the picture. And it doesn't work. You and I both know that.
And is that what happened in today's case?
It appears so, yes.
Thank you, Mr. Cusack. Your Honor, no further questions at this time.
Thank you. I'm just going to write a note. All right, Ms. Davies, cross-examination, please.
Thank you, Your Honor. Hello, Mr. Cusack. You testified that you are the crime scene reconstruction investigator who investigated this case, correct?
I am, yes.
But you were not the first investigator at the crime scene, correct?
I'm the first reconstructionist at the crime scene.
In fact, you did not arrive on the crime scene until other investigators had completely processed the crime scene. Isn't that correct?
When I wrote that, I meant processed, meaning taken images, not moved anything, if that's what you're wondering.
Since you didn't process the crime scene directly yourself, you can't guarantee that this was processed with 100% accuracy, can you?
Well, 100% accuracy, unless they were wearing completely sanitary suits or something like that. Perhaps the investigators left some DNA over from scalp hair particles that fell on the ground. So to answer your question, no.
Thank you. And for the sake of time, can you please answer with the yes or no question for the following?
I'm sorry, Ms. Davies. Sometimes my answers require more than just a yes or no for me to explain.
That is okay. But when I'm asking a leading question, please answer to the best of your abilities. You believe that you wanted more evidence, correct?
Oh, yes, absolutely. I would love to have the picture of that puzzle, but I never get it.
And the evidence that you would want includes DNA and fingerprints. Isn't that correct?
Yes, that would be so helpful. But as in many of these cases, we don't have it.
And the fact of the matter is that you don't have a single piece of concrete physical evidence that connects Avery Becker to this crime scene, do you?
Well, there's direct evidence and there's circumstantial. Now, when we have enough circumstantial evidence to convict, we take it to trial.
Mr. Cusack, that's not my question. There's not a piece of physical evidence that connects Avery Becker to this crime scene, correct?
To answer your question, no.
Thank you. Now let's address the potential evidence that was destroyed, the pictures of the blood droplets. You saw pictures of blood droplets on the way out of the kitchen towards the hallway, as well as blood splatter on the walls. Isn't that right?
I didn't see the pictures. Well, I also saw the pictures, but I was also there, so I saw them in person.
Perfect. However, after you viewed these photos, the photo files were corrupted, correct?
Yes, ma'am.
So nobody, including the jury, can see this evidence today.
No, ma'am. Unfortunately, that wasn't my loss. It didn't hinder my investigation.
And without these pictures today, nobody can attest that the information you are claiming is true, can they, regarding these pictures?
Regarding these pictures, no, I didn't really testify to them, though.
Thank you. Let's discuss the previously admitted Exhibit 12. You saw these when investigating this crime scene, is that right?
Yes, ma'am.
And you watched them?
I did.
In these videos, you can't actually see the perpetrator's skin color, can you?
You cannot, no, ma'am.
Or their face?
You cannot, no.
Or their hands?
Yes, you can see their hands.
But not the color of their hands.
No, not the color. That goes with skin color.
Nor can you determine this person's gender.
No, you cannot.
In fact, this video doesn't show a single distinguishing characteristic about the perpetrator, does it?
It does. It shows height and it shows build.
But this general height and build also relates to a very large population of people who aren't the defendant, correct?
Right. And I'm glad you brought that up because that was merely a small piece at the bottom right corner of my larger puzzle, which identified the defendant on March 6, 2020.
So that's a yes?
Yes, ma'am.
So you don't really know that the person in this video is Avery Becker, not with 100% certainty, do you?
No, we never know something for 100% certainty.
Thank you. No further questions, Your Honor.
Mr. Dinez, a redirect, please.
Briefly, Your Honor. Mr. Cusack, I have one question for you. Can you come to a conclusion using circumstantial evidence?
Oh, absolutely. So earlier I said that I was a CSR for 19 years. And in a majority of those cases, what we have is circumstantial evidence, not direct evidence, which would be fingerprints, DNA, stuff like that. You can still convict and you can still bring to trial circumstantial evidence if it's good enough. In this case, the picture is quite clear and the puzzle is not that difficult.
Thank you. No further questions, Your Honor.
All right, thank you. May this witness be excused?
Yes, Your Honor. At this time,
All right.
we'll rest.
All right, let's give the scoring judges a moment. Now, my understanding while we're scoring is that there's no halftime motions. Is that correct? I will ask Ms. Seaman and Ms. Moraine.
Yes, Your Honor, there are none from the people.
All right. And in fact, they're not even allowed. Is that right?
I do not believe so.
Okay. All right, Ms. Moraine.
It's all good, Your Honor. We're ready to proceed.
Okay, good. All right. I think we've given the judges a chance. And is the defense ready to proceed?
Yes, Your Honor.
All right, young lady, at your leisure.
The defense calls Professor Blake Van Owen to the stand.
Okay. All right, Professor, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to offer in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Please introduce yourself to the jury and spell your name.
Hello, my name is Blake Van Owen, BLAKVANOWEN.
Thank you. Ms. Moraine.
Professor Van Owen, to begin, what is your current employment?
I'm a private investigator.
And do you have any experience in the field of law enforcement?
I do. I joined the Aurora Police Department back in 2005. After that, I worked as a school resource officer, next went into private security, and finally settled on private investigation.
And have you received any specialized training or education in the field of law enforcement?
I have. I've received a master's degree in criminal justice through the Ashford University's online program.
And have you testified as an expert witness before?
Absolutely. I have testified in over 100 law enforcement related cases. 5 of those were closely related to cell tower evidence, which is very pertinent to this case today.
And have you ever testified as an expert witness in relation to your job as a police officer?
Yes, I have.
And what are your specific areas of expertise?
I consider myself an expert in the areas concerning police practices, use of force, false arrest, as well as forensic evidence techniques. And in that respect, I've been considered an expert in the states of Colorado, Arizona, Kansas, Nebraska, as well as New Mexico.
Would you please repeat your purported areas of expertise?
Yes, police practices, use of force, false arrest, and forensic evidence techniques, Your Honor.
Thank you very much.
And Professor Van Owen, have you ever had any adverse issues related to your employment as a police officer?
Yes, a while back, there was a civil suit filed against me for use of force on a young woman. The Aurora Police Department, which is who I was working for at the time, looked into it. And during that investigation, they concluded that there was no wrongdoing on my part. And ultimately, that entire experience just taught me that the protocol that I was following that was permitted by the police department is something that I don't agree with. And that's something, a pattern that I found consistently with my views and those of the police department.
The defense respectfully requests that the court qualify Blake.
Go ahead.
The defense respectfully requests that the court qualify Blake Van Owen as an expert in the areas of police practice and forensic evidence techniques.
Thank you. Mr. Dinezza, any objections or voir dire?
Yes, Your Honor. I request a brief voir dire.
Absolutely.
Professor Van Owen, you claim to be an expert in police practices. Isn't that right?
Right. I've been qualified as an expert in that area.
But you were a part of the police force for only 9 months. Isn't that true?
Right. 9 months of my career. And then I decided that I wanted to go and do another fields regarding criminal justice.
And that was in 2005, correct?
I left the police department in 2006, but yes, I joined in 2005.
So that would mean your purported evidence, or excuse me, your purported expertise is based on a 9-month experience from about 15 years ago, correct?
That was my initial experience in police practice, but as a private investigator now, I've worked with many police-related cases, and so I have a lot of experience that is developed from that part of my career.
So your experience in the police force directly was 9-month long experience from over 15 years ago. Yes or no?
Yes, but once again, I've worked with police practices since then.
Your Honor, I have no objection to the witness. Actually, Your Honor, I have an objection to both grounds of both general police practices as well as forensic techniques. As the witness's expertise or experience in regards to police practices was 9-month-long experience from over 15 years ago. Now, according,
but what about her statement that since then she's had other experience that might qualify under other cases?
Your Honor, I understand that she may have been entered as an expert, tendered as an expert in past trials. However, that holds no weight in court today. Now, if the expert would like to testify in regards to investigation strategies, I would hold no issue with that. However, police strategies is a very specific expertise that only an officer of the law would have knowledge about. Now, under Rule 702, that says that it is a conjunctive. I believe that expert testimony must rise to a threshold level of both relevance and reliability. Now, this court, as the gatekeeper, should exclude testimony in regards to both police practices and forensic evidence techniques because Professor Van Owen's experience in this regard is far too attenuated.
All right. Ms. Marine?
Yes, Your Honor, given Professor Van Owen's extensive experience and training in the field of law enforcement and her master's degree in criminal justice, she possesses the necessary knowledge, training, and skill to be qualified as an expert.
If I may, Your Honor.
You may.
Now, in regards to the master, that is theoretical and more so refers to investigation. Now, the defense would like to enter Professor Van Owen as an expert in crime scene investigation. I would hold no issue with that. However, again, I hold issue with the exact dictation of general police practices. As that regard, Professor Van Owen's experience was over 15 years ago and only 9 months long. Therefore, all of this must have been forgotten, as it, again, was over 15 years ago.
All right. I think that her background, education, and experience is sufficient to get past the starting line, and everything beyond that, as the gatekeeper, goes to weight rather than admissibility. So I'm going to qualify this expert as an expert in police practices and forensic evidence techniques.
Thank you, Your Honor. May I continue?
You may.
Thank you. Professor Van Owen, please tell the jury about your connection to this particular case.
Of course. So I was contacted by the defense to conduct a follow-up investigation. They had indicated to me that there appeared to be some evidence that the police department overlooked during their investigation.
And were you paid to work on this case?
I was. This is my job, and as any other job, I'm paid as a professional for my time. I absolutely am not paid to give any particular opinion.
And what did you do to prepare for this case?
For my preparation for this case, I looked into the police reports, Cusack's crime scene reconstruction, the cell tower reports, as well as the exhibits that Markowitz had prepared. In addition to that, I conducted my own investigation into the evidence that the prosecution and police department had overlooked.
I'd like to direct your attention to the part of your investigation that focused on the cell phone data analysis. Please explain your findings related to the cell phone data in the investigation.
Of course. So when I looked into the cell phone data, I found that Avery's phone had in fact communicated with the tower near Mackenzie Brackman's house. Now, given the inconsistency and lack of precision in cell phone data, I don't think that this evidence should hold much weight in the overall investigation.
So how did your investigation of the cell phone records differ from that of Detective Markowitz?
Well, in my opinion, Markowitz was not thorough at all in the records that he chose to obtain. He was very selective in those records that he did choose to obtain and those that he didn't. It appeared that he only focused on obtaining the records that would incriminate Avery.
Mr. Dineza, did you have an objection? I didn't quite hear.
Yes, Your Honor. Can you hear me all right?
I didn't before, but now I can't.
Okay, my apologies. I object on the grounds of speculation. Now, when Professor Van Owen was talking, she regarded, she said that, I believe it was Detective Markowitz selected certain things on a set of whims or based on certain things. She has no knowledge as to what Detective Markowitz selected evidence or looked into evidence on and what grounds. They're speculating as to what Detective Markowitz was thinking.
I'll sustain the objection and let Ms. Moraine re-ask the question.
Professor Van Owen, without commenting on why you think Markowitz didn't obtain certain records, and based on your thorough review of the evidence that was collected, how was your investigation different from that of Detective Markowitz?
Right. Well, it appeared to me that, I know for a fact that my investigation was completely open-minded. I didn't come into it with a certain criminal, certain person guilty in mind. But I do know that Detective Markowitz only looked into the records that pointed towards Avery.
I didn't hear the objection again.
Objection to on the grounds of speculation. She says she does know Detective Markowitz only did certain things. She, in fact, does not have the knowledge as to the extent to which Detective Markowitz looked into certain things. Some of this knowledge may not have been presented, but the inner workings of Detective Markowitz is mine when going about conducting this investigation is not open to her.
Ms. Moraine.
Professor Van Owen simply said that based on her review of the evidence, Detective Markowitz did not obtain certain records, and in a moment she will elaborate on which specific records he did not obtain. She did not comment on Detective Markowitz's mental state, nor the motivation behind his failure to obtain these records, and it is therefore not speculation.
Your
Objection's
Honor,
overruled. Go ahead.
Professor Van Owen, based on your knowledge of the case, which records did Detective Markowitz not obtain?
Right. Well, as I said earlier, Markowitz only looked into the records regarding Avery's phone, but not any others that could indicate of other suspects, such as Alex Cifuentes or Blair Rollins. Additionally, he did not look into any records regarding Taylor Perkins' phone, and those records would further legitimize Avery's alibi.
So based on your professional knowledge and expertise, what opinion did you form about the cell phone evidence in this case?
Well, in my opinion, the evidence gathered regarding the cell towers is inconclusive and should not be regarded as a vital piece of evidence to this case. It's also notable that the evidence is consistent with Avery's statement that the phone had been stolen.
I'd now like to direct your attention to your investigation of the intrusion into Coach Brackman's home. In your investigation into the intrusion, what did you review?
I looked at Coach Brackman's autopsy report as well as the pictures that the police took at Coach Brackman's residence. I additionally looked into the videos that were downloaded from the Ring doorbell system and also took some photos of my own.
And what did you take photos of?
The photo I took was a demonstration of a common way to hold a knife similar to that of the murder weapon.
I would now like to ask Professor Van Owen to please direct her attention to Exhibit 21. Are you familiar with this picture?
I am. This is the photo I took as part of my investigation.
And is this an accurate representation of the photo that you took?
Yes, it is.
Your Honor, may I please have permission to admit what has been marked as Exhibit 21 to evidence?
Let's take a look at it.
Could my co-counsel please share their screen?
Mhm. All right. So you're offering Exhibit 21 at this time. Any objection?
yes, Your Honor. I object on the grounds of hearsay as well as more prejudicial than probative.
All right. So insofar as you're objecting about hearsay, what's the out-of-court statement?
The out-of-court statement in this regard is that this is the way that the knife was held by the perpetrator. And in regards to more prejudicial than probative, the knife being presented, and this knife, in fact, not being the knife used in the crime, would mislead the jury to think that the way this knife is structured is identical to the way the knife used in the crime is. Therefore, it would mislead the jury, as I believe that Professor Van Owen will further testify about how the grip makes holding the knife awkward in some circumstances and more comfortable in others.
All right. Ms. Moraine?
Your Honor, the probative value of this exhibit is high because it relates to the validity of a proposed theory of a struggle. And it is also high because, as Professor Van Owen has confirmed, the make and model of this knife are similar to the make and model of the knife used in the murder. And its prejudicial value is low, as it's merely a demonstration by Professor Van Owen that is unlikely to prejudice the jury in any way. As to the hearsay objection, I am not understanding opposing counsel's assertion that it is hearsay because it is a demonstration, and I do not believe that it is calling for any out-of-court statement being used to prove the truth of the matter asserted under Rule 801.
Okay.
May I respond, Your Honor?
You may.
In regards to the more prejudicial and probative, counsel says that this knife is a similar make and model to the knife. Now, Your Honor, if you could refer to Exhibit 9, you would see that that is not the case. Exhibit 9 is the murder weapon, and that would be a false statement that counsel just made in regards to the murder weapon. And thus, this evidence would be more prejudicial than probative. In regards to the statement being made is that this is how the knife was held by the perpetrator.
So with respect to the hearsay, I'm going to overrule the hearsay objection because I don't find that it is an out-of-court statement, because I don't find it to be a statement. With respect to the second objection, which is the fact the difference between this knife and the other knife. That is exactly why we have cross-examination. That's a factual determination, and you can beat this witness up on cross-examination about that if you'd like, but it's admissible, so the objection's overruled.
Yes, Your Honor.
Professor, what does this photo show?
This photo shows a common way that a knife of similar magnitude as the murder weapon would be held.
And according to your expertise, what is the most common way for such a knife to be held?
Well, as you can see, there are grooves on the bottom of that knife that are meant to mirror the shape of your fingers. So it's likely that you would hold the knife with your fingers in those grooves, which would leave the blade facing upwards.
And why does the position of the knife matter?
Well, based on my review of the autopsy report, the stab wound found in Coach Brackman's back shows that the knife came from an upward angle. If the knife was being held, as I suspect, once again with that blade facing up, the prosecution's explanation of a struggle resulting in the stabbing is inconsistent with the forensic evidence.
How so?
Well, for Coach Brackman to have died during a struggle, as Markowitz concluded, the victim and the perpetrator must have been facing each other, and the perpetrator would have to reach over Coach Brackman's back and stab him in the shoulder, nicking the aorta. This would require the perpetrator to be significantly larger than Coach Brackman.
And why is this a problem?
Well, this is not only inconsistent with the defendant, Avery Becker's height, but also the perpetrator that we can see on the Ring doorbell videos.
So what then, according to your professional knowledge and expertise, do you think happened?
Well, in my professional opinion, as well as my review of all the evidence, I believe it makes far more sense that Coach Brackman was sitting while the intruder was standing behind him. It is addition.
Objection, Your Honor. Outside of the scope of this witness's expertise, this witness is an expert in the field of police practices and forensic analysis. However, she's not an expert in the field of crime scene reconstruction and therefore cannot testify in this regard.
Counsel?
Your Honor, based on Rule 703, this witness does reasonably rely upon crime scene reconstruction in her field of work to form her opinions about the case, and it therefore falls under the scope of her testimony, because Rule 703 states that an expert can base her opinion on facts or data that they have been made aware of and that an expert in the field would reasonably rely upon. And as a private investigator and a qualified expert in the area of forensic evidence, Professor Van Owen certainly relies reasonably upon the crime scene reconstruction when forming her opinions.
Mr. Dineza?
Yes, Your Honor. It's referring to facts or data. The practice of crime scene reconstruction is neither a fact or a piece of data. Therefore, this expert cannot testify in the field of crime scene reconstruction as her opinion is specifically in that regard and not in regards to police practices or forensic analysis. Now, if they were to use if they were to use Rule 703 in that regard, it would be as if they would rely on the coroner's report to make a conclusion, and that would be acceptable. However, the use of Rule 703 is improper in this situation.
All right. I disagree with your assessment regarding facts and data. If, in fact, there's testimony that this is something that an expert reasonably relies upon, the reason I'm going to sustain your objection, Mr. Dineza, is that there has been no foundational evidence that this is the type of, even if we can assume that, well, even if one might assume it, there's no basis for assuming it here. So there's no evidence from this witness showing that this is the type of testimony that an expert in this field typically relies upon. For that reason, the objection will be sustained.
Thank you, Your Honor, and I have no further questions.
Thank you. All right. What is next?
I pass this witness for cross-examination.
Okay. Hold on just a moment. All right. Mr. Dineza.
Professor Van Owen, one of the reasons you quit police work is because you became disillusioned with it.
I quit police work because I didn't agree with many foundational values that the police department had.
And you said you became disillusioned with it, correct?
Right.
Because of an incident in which you were sued, correct?
The suit was eventually dropped, but right, there was a suit filed against me.
And since that time, you've considered yourself a bit of a crusader for social justice, isn't that right?
Well, I like to think that my job provides justice when the police department has dropped the ball. And so I do work hard to really find the areas where the police department has neglected to investigate.
So that's a yes to my question.
That's one way to put it, yes.
And in fact, that's what you teach, social justice.
Right.
You just testified that you've been endorsed as an expert on multiple occasions, as well as consulted for numerous cases, correct?
Right, that's been the bulk of my career.
However, all of these involvements have been for the defense.
Well, unfortunately, the defense does not have the same resources that the prosecution does.
My
The defense,
question was not about the resources the defense has. My question was if all of these have been for the defense, yes or no?
right, I'm telling you why.
I
The
didn't ask
defense,
why. I simply
It's
asked.
a yes, no question. It's a yes, no question. Go ahead and answer yes or no.
yes, I commonly work for the defense.
In each of these 100 cases where you consult for the defense, you're paid for your opinions.
Well, it is my job, and it is a job that I worked hard. I had to take, get an extra degree in to work here. And so just like you're being paid to be present today, I am as well.
So that's a yes, my question.
Yes.
Isn't it true that if you don't find anything favorable for your client, you wouldn't get paid nearly as much?
Well, I would still get paid for my time and my preliminary investigation. And I ultimately think the most important thing is that I find justice. I'm not worried about how much I get paid when I work and do what I do.
And that's between about $6,000 and $10,000 per case, correct?
Right. I don't know the exact numbers, but that does sound correct.
Now, you were retained to review the police investigation, correct?
Right. That's what I did.
Your job was to find something wrong.
Yes. I was looking for areas where the police had dropped the ball, and I ultimately did find that the police did neglect some evidence.
However, you didn't visit the scene of the crime, did you?
No, that was not my job. My job was to look at the evidence that the police department had collected and evaluate that.
My question simply called for a yes or no answer. You didn't visit the scene of the crime. Yes or no?
No, I did not.
Nor did you take any pictures on the scene.
Right. I relied on the pictures that the police department collected.
And nor did you personally observe the body of Mackenzie Brackman.
That is also correct. Yes.
But Detective Markowitz did, didn't he?
Right. It is my knowledge that Detective Markowitz did go to the crime scene.
And so did Kyle Kuzak.
Yes, he is a crime scene reconstructionist, so I would hope that he visited the crime scene.
Now, let's talk about the knives in Exhibit 21 as well as Exhibit 6. Now, if you look, permission to share what has been previously marked as Exhibit 6. Do you know what this is?
Yes, that is the murder weapon.
And is it a fair and accurate representation of what you viewed when you were conducting this investigation?
Right. This is the picture that I viewed. I never actually saw the murder weapon firsthand, but this is the picture that I've been referring to.
Your Honor, at this time, the people move to enter, the people move to enter Exhibit 6 in evidence.
Any objection?
Yes, Your Honor. Professor Van Owen lacks foundation because she does not have personal knowledge of the exhibit, as she just said that she didn't see it firsthand, nor did she visit the crime scene, and that she therefore cannot authenticate it for its admittance.
All right.
Yeah.
So, Mr. Daneza, why are you asking that it be admitted? Does firsthand knowledge, is firsthand knowledge required?
No, in fact, firsthand knowledge is not required. I'm simply entering this exhibit so that I can compare it to Exhibit 21, in which counsel previously noted it was quite similar to this weapon that you're seeing before you right now.
Objection will be overruled. It'll be admitted.
Your Honor, permission to share both Exhibit 21 and Exhibit 6.
Sustained. Granted.
Now, looking at these knives, are they a similar make?
Yes, they are. They both have a groove on the bottom to replicate the fingers for, maximum comfort while it's being held.
Do they have a similar grip?
Yes, they do. They both have that groove.
And do they look remotely similar at all?
Yes.
You can stop sharing the exhibits now. Now, Earlier, you testified that in your opinion, Detective Markowitz neglected potential evidence.
I did.
You think he should have obtained the cell records of Taylor Perkins
Absolutely.
and the complete doorbell records.
That is correct.
However, you never obtained this information, did you?
The fact that the police department neglected to obtain those records in the first place is enough for me to conclude that they were not thorough in their.
Objection. What's your objection, Mr. Denoza?
I have no objection. I'm simply trying to control the witness. I asked that you never obtained this information, did you?
No, I didn't, because the fact that it wasn't obtained in the first place is enough for me to conclude that the investigation was not thorough and not conclusive.
And Professor Van Owen, I didn't ask about your opinion on the investigation. I simply asked if you obtained this information.
Objection, Your Honor. Asked and answered. Mr. Dineza has already asked this question and Professor Van Owen has already answered it with a yes and then her elaboration.
All right, I'll let it come in. The objection's respectfully overruled.
I'll ask the question again. Yes or no, you did not obtain this information?
No, because it wasn't necessary.
And nothing prevented you from obtaining this information?
No, but I'm here testifying to prove that Avery is innocent. I'm not here to convict another suspect.
You believe that the intruder brought their own knife, correct?
That is correct, yes.
You reviewed all of the images the prosecution provided, correct?
Yep, very thoroughly.
Include the coroner's report as well as the Ring doorbell videos.
That is correct.
As an expert, you rely heavily on these things, don't you?
Right, the evidence provided.
Now, in the autopsy report specifically, the incision was said to be approximately 7 inches deep, correct?
Yes, that is correct.
Now, this would mean that the knife is approximately 11 inches long, if we include the handle.
Right, we saw a measurement of the murder weapon.
Now, permission to share what has been previously marked as Exhibit 12.
Go ahead.
I believe this has been previously admitted into evidence, Your Honor.
It has. It has.
Professor Van Owen, nowhere in this video do we see the intruder holding a knife.
No, but I presume that the knife was held under the clothing. I know that in most cases, intruders and murderers don't carry their weapons out in the open.
If you personally observe the perpetrator holding an 11-inch long knife, yes or no?
No, but I presume that it could be held under the clothes of the perpetrator.
Thank you. Now, you also reviewed Exhibit 10 and 11, correct?
That is correct.
And nowhere in any of these videos do we see this 11-inch long knife, do we?
No, and once again, I presume that the perpetrator had it under their clothes because most people don't like carrying murder weapons around in the light of day.
Witness?
I'm sorry, Mr. Neza. As it turns out, I think the problem I'm having hearing you is that when both voices are going, one gets drowned out. So go ahead with your objection or your statement.
My objection was unresponsive. I have asked this witness numerous yes or no answers, and the witness continues to give drawn-out explanations.
That objection is sustained. This is stuff that can be resolved again on if they were redirect and recross and all. So objection sustained. Go ahead.
In all of the videos, there is no image or video of the intruder holding an 11-inch long blade. Yes or no?
Not visibly, no.
Now, let's talk about Blair Rawlins. Did you review the audio tape of the trial of Jonathan Rawlins?
I did.
And the speaker was Blair Rawlins' father, correct?
Correct, Jonathan Rawlins.
And he made this claim as he was being escorted to jail, correct?
Yes, that is correct.
It was not, in fact, Blair Rawlins.
Sorry, I think you glitched out a little bit. Can you say that again?
Of course, this was not, in fact, Blair Rawlins.
Right, no, this was Jonathan Rawlins.
And nowhere in your statement do you say you reviewed videotapes of this trial, correct?
Correct.
So you have no personal knowledge about whether Blair Rawlins was present during the trial of Jonathan Rawlins, correct?
I don't. I simply provided the evidence that Jonathan Rawlins said what he said in court.
Thank you. No further questions, Your Honor.
All right. Redirect, please, Ms. Murray.
Yes, Your Honor. Professor Van Owen, are you paid to form a particular opinion about the cases that you review?
Absolutely not. My getting paid is simply something that comes along with my pursuit for justice.
And in this particular case, in the ring videos, is the perpetrator holding a knife?
Not that I can see, but I do presume that the knife was held under the clothing.
Thank you, Professor. Your Honor, I have no further questions.
All right, thank you. May this witness be excused as well? Okay. All right, thank you. We will take a moment for the judges and then we'll call the next witness, please. All right.
The defense would like to call Mr. Taylor Perkins to the stand.
Mr. Perkins.
May I begin?
You may hang on just a moment. There we go. Raise your right hand. You solemnly swear and affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. Please introduce yourself to the jury.
Sorry.
Go ahead.
Okay. My name is Taylor Perkins.
Ms. Donda.
Mr. Perkins, do you know someone named Avery Becker?
Yeah, I know Avery. She's my best friend.
Do you also know someone named Alex Cifuentes?
Yeah, I know Alex.
Please tell the jury who Alex is.
Alex was one of our teammates on the mock trial team.
How would you describe Alex's personality?
Well, Alex just has this way of being totally insincere in a kind of passive-aggressive way.
Objection, Your Honor. This is improper character evidence.
Donda.
Your Honor, this certainly is not improper character evidence under Rule 404, as the relevance of this testimony is extremely high, as it goes to the relationship between Alex Cifuentes and Mr. Perkins.
Ms. Dino, I'll give you the last word on this.
Thank you, Your Honor. Under Rule 404A1, evidence of a person's character or character trait is only admissible if it is being used. It's inadmissible to prove that on a particular occasion, the person acted in accordance with that character or trait. Mr. Perkins saying that he was insincere gives him a trait that he could act in accordance with on this day in court, which is what opposing counsel is trying to prove. Therefore, it is improper character evidence.
All right, Ms. Donda, one more briefly.
This certainly, again, is not improper character evidence, as its relevance outweighs any improper character evidence.
All right. This time I agree with Ms. Dino under 404A1, and I'm going to exclude it. The grounds given by Ms. Donda don't really resolve the 404 problem. They go to other issues, for example, relevance. The objection is sustained.
Yes, Your Honor. From what you know, Mr. Perkins, do Alex and Avery know each other?
Yeah, we were all on the mock trial team together, so yeah, they knew each other.
Can you describe the relationship between Avery and Alex from how you observed it?
Well, I knew Avery pretty well enough to know that they never really got along. I mean, they were always fine on the surface, but deep down, I don't think they were ever really friends or anything like that.
Objection, Your Honor. The witness is speculating.
Ms. Donda.
Mr. Perkins is not speculating, as I have already laid adequate foundation to establish his relationship to both Avery and Alex. Therefore, he has personal knowledge under Rule 602.
You know, I agree with Ms. Dino, but I'm going to let it in anyway because of what we're doing here today.
Now, moving on. Were you on the mock trial team at Colorado High School?
Yeah, I was.
How long have you been on the team?
I was on the mock trial team for a pretty long time.
Did there come a time when you were no longer on the mock trial team?
Yeah, I ended up stepping down after Avery got demoted.
Did you ever run into the mock trial team outside of school?
Yeah, I mean, we went to the same school together, so obviously I saw them there. But there was one time on March 5th at the Fry Shack that was specifically bad.
What happened on the evening of March 5th at the Fry Shack?
Well, Avery and I had gone there to go get some food, and it ended up being a pretty bad idea because the whole mock trial team went there after practice, and it got pretty awkward.
Can you explain the interaction between Avery and Alex that day from how you observed it?
Well, yeah. So Alex came and sat down at our table and was talking to us, and this really got to Avery so much so that she ended up storming off to the bathroom without her phone, which is so not like her.
What happened after Avery went to the bathroom?
Well, I had to keep up conversation with Alex for a few minutes, and then Avery came out and we just left.
When was the last time you saw Avery's phone?
The last time I saw Avery's phone was sitting on the table at the Fry Shack.
Did you and Avery look for her phone?
Yeah, well, that next day, March 6th, we had realized that she had lost her phone, so we ended up spending the whole day retracing our steps, but we couldn't find it.
So, can you explain to me a little more? Where were you and Avery on March 6th?
Well, like I said, we retraced our steps, so we went to the Fry Shack. We had gone to the mall the night before, so we went to the mall too, but we just couldn't find the phone anywhere, and we ended up burning the whole day.
Was Avery Becker near Mackenzie Brackman's house on the day he was killed?
No, Avery Becker was nowhere near Mackenzie Brackman's house.
Are you sure?
Positive.
How are you sure?
Because Avery Becker was with me.
Now, moving on, do you know someone named Blair Rollins?
Yeah, I know Blair.
How do you know Blair?
We go to school together.
What do you know about her?
Well, everyone that knows Blair knows she's a little unhinged. I mean, like, I don't know. She just gives off that weird sort of vibe.
Objection, Your Honor. This is improper character evidence.
Briefly, Ms. Donda.
This is not improper character evidence as Mr. Perkins is simply testifying to his rational perception and goes to Miss Blair's character.
On this one, I agree with Ms. Donda. I don't think it's character evidence. I think it does go to perception. It's a close call, but I'm going to overrule the objection.
Thank you, Your Honor. Mr. Perkins, simply based off your personal observations, do you know if Alex and Blair know each other?
Yeah, from what I knew, they were pretty good friends.
And based on your observations and from what you personally know, did Alex and Blair have anything in common?
Well, once again, from what I know, they both have reasons to not like Coach Brackman.
Based only on what you know, why did Alex hate Mackenzie Brackman?
Well, from what I know, Alex felt as though Mackenzie Brackman was always overlooking her talents.
And to your observation?
That's speculation.
Ms. Donda?
Your Honor, it is not speculation, as I simply asked Mr. Perkins to testify based only on what he knows and from what he has observed, and therefore he has personal knowledge under Rule 602.
Well, based upon the objection, I think it would be sustained. But on the other hand, in a typical trial, that foundation would have been laid, I'm sure. So for our purposes, I'm going to overrule the objection, but it's a very well-founded objection.
Thank you, Your Honor.
Mm-hmm.
Based on your observations, do you know why Blair Rollins hated Coach Brackman?
Well, from what I know, Blair resented Coach Brackman for losing the court case that got Blair's dad sent to jail.
So, Mr. Perkins, based on your close relationship with Avery and from your observations from being on the mock trial team, do you think Avery Becker had a motive to harm Mackenzie Brackman?
No, I don't think Avery would have ever harmed Coach Brackman.
Thank you, Your Honor. I have no further questions, and I pass this witness for cross-examination.
Thank you, Ms. Donda. Ms. Dino?
Yes, Your Honor. Mr. Perkins, you gave a witness statement in this case, correct?
Yeah, I did.
You talked to the defendant before writing that witness statement down, didn't you?
Yeah, I did.
In fact, you talked to Miss Becker twice before ever writing anything down. Isn't that correct?
Well, yeah, I mean, we're best friends, so it makes sense we talk, but yeah.
So you and Miss Becker were best friends, like you just said.
Yeah, I mean, Yeah, for as long as I can remember, at least I've always been best friends with Avery. I mean, yeah, I
Thank you.
love Avery to death.
So if she was in trouble, you would want to help her out, right?
Well, yeah, I mean, like within reason, I wouldn't kill my own mom if Avery told me she
Thank
was in trouble and needed it. But within reason, yeah, I'd help out my friend.
So, in fact, on multiple occasions, you made sacrifices for Miss Becker.
Well, I mean, like, depends on what you call a sacrifice. I mean, to me, everything I ever did for Avery was never that big of a deal to me.
You gave up your spot on the team so she could get back on, correct?
Well, yeah, but like, I mean, to be honest, I don't think I ever would have even been in mock trial to begin with if it wasn't for Avery. And I didn't care about it nearly as much as she did.
And then you skipped school on a whim to help her find her phone, yes or no?
Well, I mean, we're teenagers. Like, it didn't take that much to convince me to skip school. And like, obviously I wanted to help my friend out.
Okay. Ms. Dino?
Your Honor, this is an unresponsive witness. I've asked multiple yes or no questions, and he continues on to not answer that question and to go over the scope of the question.
Your objection sustained, but there's no pending question, but go ahead and ask and we'll see what happens.
On March 5th, you were with the defendant at the Fry Shack, correct?
Yeah, I was at the Fry Shack.
And she had her phone with her, didn't she?
Yeah.
She was very attached to her phone, right?
Yeah, I mean, she took it most places with her, yeah.
So she was very attached, but you say she forgot it once at the table at the Fry Shack and again when you two actually left the Fry Shack, correct?
Well, yeah, I mean, I think it was just because she was so rattled from having to see the whole mock trial team there. But yeah, she did forget her phone those 2 times.
So let me confirm. It's your story that Miss Becker didn't notice her phone was missing when you guys left the Fry Shack, when you went to the mall afterwards, and at home. That's your testimony.
Well, yeah, I mean, that's what happened. So, yeah.
And then the next morning, she got up, she got ready for school, and she drove to pick you up and still didn't notice until you said something, correct?
Well, yeah, I mean, she must have been busy or something. But yeah, I got in her car and that's when we realized she didn't have her phone.
So you testified that you guys spent hours driving around looking for her phone, correct?
Yeah, I mean, we were retracing a whole day, so there was a lot of spots to hit. But yeah.
So, Mr. Perkins, why didn't you just pick up your phone and call all the places you went on your way to school?
I mean, hindsight's 2020. Like, when you look back on it, there's 100 better ways you could have done something, but we just went with what came to our minds at the time, I guess.
And one of those better ways would to be use the iCloud website, right? Because that could have tracked it easily.
Well, yeah, but I have Samsung, so I couldn't have done it with the app. And we forgot at the time that you could do it on the website.
So you testified you think Blair Rollins could have been involved in Coach Brackman's death.
Well, yeah, I mean, I heard from kids that were at school that day that she wasn't there either. And I mean, everyone knows that Blair always resented Coach Brackman for getting her dad sent to jail. So
it was the defendant that came up with this idea that Blair was involved, wasn't it?
Yeah, I mean, I guess it's just her mind for mock trial helps her look at legal cases good or something.
You actually have no personal knowledge about whether Blair Rollins was involved, do you?
Well, no, I mean, I can only, I'm not a cop or anything. So who was involved, I don't think is really for me to say. I think I'm just here to say that I know it wasn't Avery.
You testified that while you and the defendant were driving around, you were nowhere near Coach Brackman's house, correct?
Yeah, I mean, that's true. We weren't anywhere near there.
And you know where his house is.
Well, no, I don't actually know where Coach Brackman's house is. I just know that we were at the mall in the Fry Shack, and unless he knows where that lives near there.
If you don't know where his house is, then you wouldn't know if you were near or not, would you?
Well, yeah, I mean, I guess I technically didn't know if I was near there or not. I just know we weren't trying to go there or anything like that. We were just hitting stores.
Were you at Coach Brackman's house on March 6th?
No, I was not.
Are you sure?
Positive.
And do you recall giving a witness statement in this case?
Yeah, I did.
And do you remember saying it was creepy to think about Brackman bleeding on his porch?
Well, yeah, I mean, from what I heard about what happened, he was bleeding on his porch, right? And yeah, it is creepy to think I was going through my regular day while someone I knew was dying.
You heard today in court that he actually wasn't found bleeding on his porch, was he?
Well, yeah, I guess not. I don't know. Like I said, I don't actually know what happened.
Whoever it was that first called 911 was the one who said he was bleeding on his porch, wasn't it?
Presumably, like I said, I'm not a cop. I don't really know the details of this case. I just know what I was doing that day.
You and this unknown 911 caller have identical, incorrect accounts of where Coach Brackman was found, correct?
Well, yeah, but if I was there and I called 911, wouldn't I have known where he, like if I was involved, wouldn't I have known where he
Thank you,
ended
Mr.
up?
No further questions, Your Honor.
Ms. Dunn?
Mr. Perkins, why did you leave the mock trial team?
Well, Avery just deserved to be on A team more than I did. And to be honest, it wasn't even that much fun once I didn't get to practice with Avery anyway.
And where were you on the day of Mackenzie Brackman's murder?
Like I said, I was retracing my steps from the night before trying to find Avery's phone.
And where was Avery on the day of Mackenzie Brackman's murder?
Avery was with me.
Thank you, Your Honor. I have no further questions.
All right, thank you. May Mr. Perkins be excused? Thank you. Thank you for your testimony, Mr. Perkins. Ms. Davies, next witness, please.
We call Avery Becker to the stand.
All right, hang on just a moment. Ms. Becker, please raise your right hand. Solemnly swear or affirm under penalty of perjury that the testimony you're about to offer in this matter will be the truth, the whole truth, and nothing but the truth.
Yes.
Okay, please introduce yourself to the members of the jury.
My name is Avery Becker. That's Becker.
Thank you, Ms. Davies.
Thank you, Your Honor. Good evening, Ms. Becker. Can you please introduce yourself for the jury?
Yes, like I said, my name is Avery Becker.
Why are you testifying here today?
I'm testifying because I will prove that I did not commit the crime I'm being accused of.
To start off, I'm going to ask you some personal questions. Were you on the mock trial team at Colorado High School?
Yes, I was. I love mock trial. I was a part of it for all 4 years. It was one of my favorite things.
What do you like so much about it?
Well, one of my favorite parts was getting to spend time with people that I didn't have a lot of classes with in school. So it was just a great time for the two of us to catch up, me and Taylor and other people. And I also loved mock trial because it did come pretty naturally to me.
Who are some of your friends on the team?
Like I said, Taylor was my best friend on the team. Taylor and I joined mock trial together, and it was a perfect time for the two of us to catch up. We liked hanging out and texting from across the room.
Is there anybody who you didn't get along with on the team?
Well, I would say that I'm fond of most people who were on my mock trial team, but there was always something off between Alex Cifuentes and me. It wasn't that we didn't get along, but from what I observed, it seemed that Alex was almost jealous of my natural mock trial abilities.
Objection, Your Honor, speculation.
Davies?
Your Honor, this is not speculation, as Ms. Becker is allowed to testify to her personal knowledge and perceptions.
Ms. Seaman?
Although Ms. Becker can testify to her own perceptions, she is testifying to Mr. Cifuentes' mental state of jealousy, and therefore she is speculating on how he felt.
All right, so the answer started with the word "it seemed," and that to me is an expression of her own sort of knowledge and experience. So I don't find it to be speculative. The objection will be overruled.
Could you please further explain more about why you observed that Alex seemed jealous to you?
Of course. So, as I said, I did have quite an aptitude for mock trial when I was on the team, and Alex was really good at mock trial too. However, Alex came to practice more than I did, and I missed practice a few times, but Alex worked really hard at it. So when I would win the awards and I would do well at mock trial, it just appeared that Alex was jealous.
Now turning to Coach Brackman, did you ever have any differences with him?
I mean, with every relationship, there are ups and there's downs. Coach Brackman thought I needed to work harder and come to practice more, but he knew that I had an instinct for mock trial. But when I found out that Coach Brackman had been murdered, I was devastated.
You must have been. Were you involved in an accident with Coach Brackman's car?
Yes, I was.
Okay, please explain this incident for the jury.
So before regionals, Coach Brackman had bumped me down to B team for a while because he claimed I was never prepared, but eventually moved me back up. And at regionals, I ended up winning Best Attorney Award and even Best Closer Award. But after the tournament, Coach said that I didn't deserve the awards and that I was going to make the team look bad at state because he said I was just relying on my good looks and that it was out of luck.
And what happened next?
I was really angry. I stormed out of mock trial practice and I had a whiteboard marker in my hand because we'd been doing something on the whiteboards. But I later learned this was a permanent marker. I took said marker and drew all over Coach Brackman's car. I thought it was a dry erase marker. I would never, ever intentionally draw on Coach Brackman's car with permanent marker, or anyone's car, no matter how mad I was. I thought it would come right off. And understandably, after that, Coach Brackman kicked me off the team.
Did you ever try to apologize to him?
Yes. The next day, I went to his office, but his secretary said he was busy and couldn't talk to me. So I then sent him a text message and told him how sorry I was. I said I would try and clean the car myself, get a summer job in order to pay to get the car repainted, anything, just anything to fix my horrible mistake. But Coach Brackman never responded. So I never got the chance to apologize to him before he died.
Let's move to the day that Coach Brackman was killed. Do you remember where you were that day?
Yes, I do. I remember it clearly. The day before, which was March 5th, I was with Taylor at the Fry Shack, and we had also gone to the mall. But I had lost my phone, so then the next day, on March 6th, I went to Taylor's house, and we decided to skip school to look for my phone. Taylor and I were together the whole day because we were retracing our steps at the Fry Shack and the mall, and kept using Taylor's phone to call mine, but it never picked up, so I just figured it was dead or even stolen.
Is there any time during that day that you weren't with Taylor?
No. Like I said, Taylor and I spent the whole day together, retracing our steps from the day before to try and find my phone.
Do you have any idea where your phone was?
Well, I know for a fact that on March 5th, I had it at the Fry Shack because Taylor and I were actually playing video games on our phones. And a bunch of people from my school were there, including some people from the mock trial team, as well as Alex Cifuentes. I think Alex took my phone.
Objection, Your Honor, speculation.
Ms. Davies?
Your Honor, my witness is just testifying to her beliefs based on the events that took place, and my next following questions will explain why she believes this.
Notwithstanding the prefatory statement, I do think it's speculative, so I'm going to sustain the objection.
Okay. Do you have any information that supports your belief of where your phone was?
So it's my understanding that Alex claimed to have received a series of text messages from me stating that I wanted to get back on the team. And apparently I texted him and told him that I was going to go to Coach Brackman's house to trash it. But firstly, I never did that. And I never would have texted that. And secondly, I don't even know where Coach Brackman lives.
Moving on, can you please take a look at what has been previously admitted as Exhibit 14?
Yes, I can.
Remind us, what does the time say on the text messages?
So it actually doesn't look like there's a time attached to these text messages.
Did you send these messages?
Absolutely not. Like I stated earlier, my phone was missing, so I could have would never have texted Alex without it.
Moving on, do you know Blair Rollins?
Yes, I do. Blair was another student at my high school. From what it seemed to me, it seemed like Alex and Blair were close friends. However, I wasn't very close with Blair. I do know that Blair didn't have a great relationship with Coach Brackman, as Coach Brackman lost Blair's father's case, which ultimately sent Mr. Rollins to jail.
Was there an objection?
Yes, lack of foundation, and then speculation. The foundation has not been laid that she knows Blair Rollins. In fact, she said that she's not friends with Blair Rollins and therefore would be speculating on how he feels in this instance.
Ms. Davies.
Your Honor, Ms. Becker, she didn't say what Ms. Seaman claimed. She said that Blair is another student at Colorado High School, which means that she did in fact go to school with Blair. And she did note that she observed Blair's relationships with other people who she also knew.
I'm going to let it in. The objection will be overruled.
Moving on, Avery, can you describe Blair's physical appearance?
Yeah, so Blair and I actually had a similar height and an overall similar build too.
Looking at what has been previously admitted as Exhibit 12, can you please take a look at these exhibits?
Yes, I can.
What are they?
So this looks like a video of an intruder walking up to what I assume is Coach Brackman's door, the front or the back. I wouldn't know because I didn't know where Coach Brackman's house was and don't know what it looks like.
Can you recognize any of the intruders' appearances and relate them to yourself?
Yeah, so from this short clip, I do notice that the intruder's height is similar to mine, but that just as well means that the person's height and build is similar to Blair's, and you can't tell who this person is as they're wearing long sleeves and a mask.
Finally, Ms. Becker, did you kill Coach Brackman?
Absolutely not. The only thing I did was damage Coach Brackman's car. I never shouldn't have done that. And I did not kill Coach Brackman. I just can't even believe that I'm being accused of it.
Thank you, Your Honor. No further questions, and I pass this witness for cross-examination.
All right. And let's have cross-examination.
Thank you, Your Honor.
Mm-hmm.
Ms. Becker, you thought you were the best on the team, didn't you?
Well, I would say that I was the best at improvising, yeah.
And you hoped to win Best Attorney in State.
I did. I had won Best Attorney Award at regionals, so I wanted to carry that on and just make an even better accomplishment my senior year in mock trial.
But Mr. Brackman stood in your way.
Well, Coach Brackman always wrote scripts for us, and I knew that in order to win those awards, I needed to ad-lib from the scripts. So I guess you could say that.
And he criticized you often.
I think because Coach Brackman worked so hard to become who he was as a lawyer, it bothered Coach Brackman that I was able to do things on the fly. So he often did criticize my work, yes.
And you thought he hated you, yes or no?
I mean, he hated me I wouldn't say he hated me as a person, but he definitely didn't enjoy my presence all the time at mock trial.
And he made you so angry that you vandalized his car.
I did.
Objection, improper character evidence.
Response?
Yes, Your Honor. Under Rule 404B2, character evidence is admissible if it goes to show motive, intent, or opportunity. In this case, showing Ms. Becker vandalizing Mr. Brackman's car is going to show her motive after he kicked her off as a response for this and her motive to kill him or to vandalize his house afterwards.
Ms. Davies?
Your Honor, this is not going to show Ms. Becker's reputation for having a character for truthfulness or untruthfulness, so I stand by my objection.
All right. I don't think it's 404B, and I also am not sure that it's character evidence, so I'm going to overrule the objection and admit it.
So you vandalized his car, didn't you?
I did. It was the worst mistake I've ever made.
And after that, you went home and you talked to your mom.
Yeah, after I'd been kicked off the team, I was obviously very upset. So I went home, I was in tears, and of course I talked to my mom.
You told her that you would get back at Mr. Brackman if it was the last thing you did.
This was my senior year on mock trial. I wanted to go to the state tournament and I wanted to win those awards. I was so frustrated. Everything that I did that night was so not me. So yes, I did tell my mom that, but I didn't mean it.
Excuse me, Ms. Becker. Yes, you told her you would get back at Mr. Brackman if it was the last thing you did.
Yes.
Now, you're aware of Exhibit 14. The final two text messages say, I'm going to wait until he's at work, then break in and trash it. That will show him.
I do believe that's what they say, but I obviously did not send these text messages.
But these text messages are about getting back at Mr. Brackman.
These text messages are, but these text messages did not come from my phone, or did not come from me.
But they match what you told your mother.
I'm sorry, I couldn't hear you. What was the question?
They mirror what you told your mother.
I mean, obviously, I told my mom that I wanted to get back at Brackman, but that has nothing to do with these text messages. These text messages say that I wanted to trash Coach Brackman's house. I don't even know where Coach Brackman lived. I would never do that.
And your phone is important to you, correct?
Of course.
You joined mock trial to be on it?
I mean, it didn't join mock trial for the sole purpose to be on my phone, but one of the pluses was being able to hang out with Taylor and text from across the room.
Exactly. You were with Miss Perkins on March 6th.
Yes.
She joined mock trial for you, didn't she?
We joined together.
She quit mock trial for you.
Taylor knew that in order for the team to succeed at state, that I needed to be on the team. And since Taylor didn't care as much about mock trial as me, it made sense for Taylor to drop down from the team.
And he would do a lot for you, wouldn't he?
Taylor's my best friend. I wouldn't say that he would go to extensive matters like he said. He wouldn't kill his mom for me, but of course, we were good friends.
So your best friend, Taylor Perkins, is the only person who knows where you were on March 6th.
It was a school day, so most of our other friends and most other people that we know were at school, and the adults in our lives were at work. So Taylor and I were the only people that we know at the mall and at the Fry Shack on March 6th. Yes.
He was the only person who knew where you were.
Yes.
No further questions, Your Honor.
All right. Just a minute. Davies?
Yes, Your Honor. I just have a brief redirect. Why did Mr. Perkins quit mock trial?
Like I said, my friend Taylor didn't care as much about mock trial as me, and Tay also knew that in order for our team to succeed, I needed to be there. So it made sense for Taylor to drop mock trial in order for the team as a whole to succeed, not just me.
And finally, do you have an alibi?
Of course. I was at the mall and the Fry Shack with Taylor on the day of March 6th when Coach Brackman was killed. We did not go anywhere else. We simply spent the entire day trying to find my phone.
Thank you. No further questions, Your Honor.
All right, thank you. All right, now may this witness be excused?
Yes, Your Honor.
All right, good. Let's give our judges a moment. While the judges are filling out their notes, are there any other witnesses for the defense?
No, Your Honor, that's it.
All right, that's what I thought. So now it's time for closing arguments. And we will start with the people.
Yes, Your Honor. May I proceed?
You certainly may.
Everyone has a breaking point, and Avery Becker is no exception. After an endless barrage of criticism, insults, hatred, and demotion from her mock trial coach, Mackenzie Brackman, she reached her breaking point. And in her own words, she would get back at Mr. Brackman if it was the last thing she did. And that is why we are here today. The evidence and testimony presented today has shown that Avery Becker, while attempting to vandalize Mr. Brackman's home, was surprised by his presence. She then fought him for control of his knife, grabbed the knife, and stabbed him in the back. Did she intend to kill him beforehand? It doesn't matter. What matters is that she attempted to vandalize his home, and now he is dead. The defendant has been charged with 2 crimes, first-degree murder and second-degree burglary. To be guilty of first-degree murder, the prosecution must have proven, beyond a reasonable doubt, that the defendant knowingly and unlawfully broke into the residence of Mr. Brackman and during that invasion killed him. To be guilty of second-degree burglary, the defendant must have knowingly broken into that residence with the intent to vandalize. The prosecution has proven these elements beyond a reasonable doubt. And as you deliberate today, I want you to pay special attention to jury instruction number 8, because Ms. Becker did not have to intend to kill him beforehand to be guilty of murder. Now let's walk through this crime. First, Ms. Becker had clear motive to vandalize Mr. Brackman's home. You heard about how important mock trial was to her and how the one person who continuously stood in her way was Mr. Brackman. You heard about the fights, the rage, and the rivalry between those two. And you heard how it all built up to her getting so angry that she vandalized his car. She snapped. And when she was finally kicked off the team for good, she decided to get revenge. She hit her breaking point. Now let's look at intent. First, Ms. Becker went home and talked to her mother, where she stated she would get back at Mr. Brackman if it was the last thing she did. Then she texted Alex Cifuentes in a final effort to get back on the team. But when she realized there was no hope, she again said she would get back at Mr. Brackman by texting, "I'm going to wait until he's at work, then break into his home and trash it. That will show him." Those right there, those are intent. And then Ms. Becker skipped school, established a false alibi with her loyal best friend, Taylor Perkins, went to his home and killed him. Now let's talk about this alibi. You heard about Ms. Perkins and Mr. Perkins and Ms. Becker's unwavering friendship. Mr. Perkins joined mock trial, quit mock trial, and would have done anything for the defendant. He even talked to the defendant 2 separate times before giving his witness statement today. He also had the same wrong story as the 911 caller. Was he involved in this case? His testimony today is inherently biased and unreliable. And the story about Miss Becker losing her phone, that story is not credible. Now, Ms. Becker also had the opportunity. Detective Markowitz and Kyle Kuzak explained how all of the evidence pointed towards Ms. Becker and how the call detail records put her at the crime scene at the time of the murder. Now, the defense argues that this is about a dream and a plan, and it is. Avery's dream to win at state and her plan to get back at Mr. Brackman after he kicked her off the team. Professor Van Owen's dream to be a police officer and her plan to get back at the police department by being a crusader of justice. The defense's plan to blame Blair Rollins for the actions of Avery Becker. Now, as you deliberate, I want you to think of Mr. Brackman, a man who spent his life fighting for justice. Do not let justice fail him today. Avery Becker reached her breaking point, and there must be consequences. The people ask that you find her guilty. Thank you.
Thank you. All right, Ms. Seaman, thank you. Now, for the defense.
Yes, Your Honor. May I begin?
Yes, Ms. Davies, thank you.
The prosecution must prove, beyond a reasonable doubt, that Avery Becker murdered Mackenzie Brackman. The prosecution failed to meet this burden due to several key facts. First, Detective Markowitz conducted a rushed and sloppy investigation and considered no other suspects. Second, Avery was not at the crime scene and has a solid alibi, Taylor Perkins. Third, and most important, the evidence points to 2 alternate suspects in this case, Alex Cifuentes and Blair Rollins. The prosecution tried to convince you that Avery Becker murdered Mackenzie Brackman because she was demoted to B team. But Alex and Blair are the individuals who have motives. Alex's desire to become a mock trial star and Blair's desire for revenge against Coach Brackman for losing the case that sent Blair's father to jail. Now, let's investigate these points in more detail. First, the prosecution's key expert witness, Detective Markowitz, clearly rushed the investigation. Ms. Van Owen told you that Detective Markowitz jumped to conclusions with the knife and the cell phone tower data and never considered other suspects. In addition, Detective Markowitz ignored the fact that there is no physical evidence that connects Avery Becker to the crime scene. No fingerprints, no DNA, nothing. You can't even see who the assailant is in the Ring video. Second, Avery Becker was nowhere near Coach Brackman's house on the day of the murder. Taylor Perkins, Avery's best friend, testified that Avery lost her phone the day before the murder, and that on the day of the murder, Mr. Perkins and Avery were looking for Avery's phone for the entire day. In addition, Mr. Perkins explained that he and Avery were nowhere near Coach Brackman's house. Avery herself can confirm this. And she explained that she did not send the text messages that Alex says he received from her because she did not have her phone. Third, Alex Cifuentes had a dream and a plan. As Avery testified, Alex was jealous of Avery and wanted to get her out of the way. Alex went to every practice and prepared for every trial. However, none of this dedication or work allowed Alex to outshine Avery in competition. This is because Avery is an accomplished individual who has incredible mock trial abilities. Imagine how frustrated Alex must have felt working as hard as possible, but never being able to outshine Avery. Meanwhile, Blair Rollins had a reason to despise Coach Brackman. Coach Brackman lost a case that sent Blair's father to prison. This makes it easy to see why Blair wanted revenge against Coach Brackman. Alex had a dream and a plan, and Alex used Blair's desire for revenge in order to accomplish it. As Alex wanted Avery to go to jail, and Blair wanted revenge against Coach Brackman. This was the perfect crime, as it would ruin both the lives of Avery Becker and Mackenzie Brackman. The prosecution would like you to believe that Avery Becker reached her breaking point. You have heard all the evidence today, and evidence does not support this. But what the evidence does support is the fact that Blair and Alex are two individuals who have clear motives to murder Coach Mackenzie Brackman. Members of the jury, the prosecution did not meet its burden of proof. Not only did the prosecution shortchange its investigation, but Avery was not even at the crime scene. In fact, there is no physical evidence that connects Avery Becker to the crime scene. And most important, there are other suspects, Alex Cifuentes and Blair Rollins. Not only does Blair have a similar general height and build as Avery, but these two individuals both have clear motives to murder Mackenzie Brackman. I ask you to find the defendant not guilty.
Thank you, Ms. Davies. And Ms. Seaman?
Yes, Your Honor. May I inquire on a brief time check?
Yeah, I was going to do the same.
You have 49 seconds.
All right. Soon as, give it a moment. All right. Are you ready?
Yes, Your Honor.
Go ahead.
A dream and a plan. Mr. Brackman had a dream to teach young students about the law. He had a plan to do that through mock trial. But Ms. Becker also had a dream and a plan, a dream to be better than Mr. Brackman. She was jealous, they had a rivalry, and there was a school dispute. Like the prosecution said, it went too far. And Ms. Becker executed her plan by executing Mr. Brackman. There is only one suspect in this case. There is no evidence that Blair Rollins was involved. And you heard from Alex, he is not a suspect. Avery Becker stabbed Mr. Brackman in the back as he had done to her so many times before. Find her guilty. Thank you.
Thank you, counsel. The case is submitted. All right. Let's pull this back up on gallery view. Well done. All right, everybody catch your breath, pat yourselves on the back. We're going to let the judges finish tabulating, and then we will get started with some comments. And I know that everybody's tired, and so We'll sort of play it by ear with respect to the comments. I want to give these distinguished people an opportunity to talk while respecting your wishes to get the hell out of there. All right. Judges, are you ready for comments, or do you still need a moment? I see one thumb. All right.
Hi,
Let's start.
everybody. I'm Dana Stom. I'm just gonna go ahead and start because
Awesome.
yeah, I'm pretty well on it. Thank you all so much for being here. Thank you for having the staying power to get through this round of state. And it is not an easy task. So thanks to you and to your family and to your coaches and everybody else that have been supporting you. I have to say, I have not enjoyed case presentation this much since probably 2017. And I was absolutely thrilled to see the way that all interacted with each other. Attorneys, I'm going to tell you, carte blanche, fantastic job. Every last one of you, I thought, had a very solid performance, no matter how difficult your witnesses were being, especially some of them. That being said, I'm going to do what I typically do, which is to focus on the witnesses. Witnesses, you guys made your team perform much more tightly than I've ever seen in my 10 years of doing this. So thank you. For Team Kenya, all of you witnesses, did you guys get together and actually try to come up with as many movie and TV references as you possibly could? Because there was at least 4 times there I was very glad that I was muted because I started laughing out loud. And so mad props to you guys for pulling that out of a hat. Nice job. That had to be coordinated. It just had to be. And to Mr. Owen, yeah, nobody puts Avery on the B team. I was actually kind of disappointed that you didn't follow that up with an A team reference, talking about how you pitied the fool. But that was my only criticism on that. For Team Israel, Ms. Olivia, and I apologize, I don't want to butcher your last name as somebody whose name is usually butchered. I'm going to try really hard not to do that to your last name. In your original statements, especially when you were doing your objections, the original authenticity has not yet been established. Nicely done. Very nicely done. You did that better than I have seen seasoned attorneys pull that off. So great thinking. That was very quick-witted of you and very nicely done. Also, I really appreciated that you had the forethought to stand up and say that it has not been verified that Avery actually sent these texts. That was another really good point. And I have not yet heard that before in this competition, even through the regionals. So very nicely done. With that, I'm just going to say huge round of applause to all of you. And it's these witnesses that should give everybody a clue as to why judges and opposing counsel sit at their chair with their hand over their face, and it's to make sure that they don't actually laugh out loud or give some sort of a facial reaction to what's being said. So nice job, guys. Kudos to you and good luck.
Thank you. Ms. Cook?
Hello. I want to second the comments about the performances this evening. It is also my return to watching these mock trial competitions, and you guys are my first in a while. So thank you so much for the entertaining Friday afternoon.
Why don't you
Fabulous job by everyone.
Tell us a little bit about you.
Oh, okay.
What brings you here?
So my name is, I should actually introduce myself. Let me do that. So my name is Keisha Cook, and I'm an attorney here in Colorado. I am currently clerking with a federal magistrate judge by the name of Cato Cruz, S. Cato Cruz, and I've been with him for about 6 months. So we're working from home, as most people are, but typically we're down at the Byron Rogers building, and we're hearing both civil cases and a little bit of criminal cases, initial appearances, things of that nature. So I help the judge write orders on all those various matters. So I will tell you a little bit about myself as far as mock trial is concerned. I am a bit of a mock trial nerd. I didn't do it in high school like you all. I picked it up in law school. So when I come to these competitions, I'm really focused on your performances, how you strut in the courtroom, so to speak. And again, I want to thank you for such an entertaining evening. It's kind of a trip that we are all in our various homes and not all together, but I love the fact that you guys are killing it. And I'm just wondering what the people on the other side of the walls are thinking about what's coming from your rooms. Anyway, but as far as comments, I will just hit you with some highlights, okay? I thought everyone did an excellent job. I loved seeing all the female attorneys. You guys rocked the courtroom. You had presence. You were able to control your witnesses. I thought you did a good job on that. I did think that Ms. Seaman won the contest as far as controlling the witnesses. She was very composed. She let the witness kind of talk for a while, and she was great. Whoever played the defendant, she was great. But Ms. Seaman just let her kind of talk for a while, and then he came back. There was no stepping on toes, and I think both the attorney and the witness were able to maintain kind of their agency and be able to, but she was able to get what she needed to get out. So excellent job on that. I thought Miss Adele was great. She was soft with the opening statement, but she had great comments when you were doing your cross-examination and when you were doing your direct. I just thought you had a great presence the entire time through, even though you seem to be quieter than I am. Things I would tell you is that, speak up and state your objections, but I think also there's that kind of fine line about objections. So you just need to watch that. But if you really do, I know that you guys are tired and that you have been doing this problem over and over and again, and you're just like, I can't stand up one more time to object. I know it's going to be overruled and you're already going through that process, but that's part of the performance, right? Like, we want you to stand up, because otherwise I'm just hearing all of this stuff come in and I'm like, really? No one's objecting about foundation or, So it wasn't until later on that you guys started objecting, and that's really where you really start to see the performance from folks. So great job. Witnesses were great. I loved the defendant, but I also loved the expert for the defense side. she got Mr. Dineza on the knife. The knife was going to be this issue, and I was like, ooh. So that she got you on that, man. I'm sorry. There is a point where sometimes you're like, I gotta abandon this fight. Like, I know that like it was something that you were passionate about, but it wasn't going your way. So but overall, wonderful job, you guys. Thank you so much for your time. I'm going to allow the Miss Judd to provide comments as well. Thank you so much.
Okay, is it my turn?
It is.
Okay, this is the first time I've done this, and I'm a retired attorney, and I was knocked my socks off. I just thought you were all wonderful and so professional. And just to call out a few, well, you all seem to know the law and the rules really well, and I was particularly impressed with the way you thought on your feet and you handled the objections and argued your points on that. So actually, I thought the closings were wonderful, and I thought Miss Davies, you honed in on the very best points, and Miss Seaman, you were so professional. I thought you were probably a fourth year associate at least. I didn't get the name correct, but the person who played Avery, wow, what an actress. If you don't get into law, you should go to the theater, really. You have made such a sympathetic character, and you did everything you could with the sympathetic side of that, you know. So I thought that was really wonderful. And Miss Dino, your thinking on your feet is really phenomenal. And the men who were the witnesses, I thought I was watching TV. So I just thank you for all your effort and all your preparation. It was really a pleasure. I can't imagine I'm going to see another one as good as this.
If you do. All right, well, thank you all. My name is Barry Schwartz. I'm a Denver County Court judge, and I clerked for a magistrate judge 32 years ago, Ms. Cook, and it was a great experience. It was a long time ago, and I still remember it like it was yesterday. It was awesome. So I probably judged a number of you folks before, and it's one of the things I look forward to. And I had a really long day today. I don't think I was at my best as a judge. And I have to admit that. I don't think that my rulings were the best. And I'm sorry for that. In a way, I guess I find solace in the fact that sometimes you get a good judge, sometimes your judge sucks, and you just have to deal with it. And that's part of the beauty of what you're doing. So, you know, my kids went to East High School, and they did mock trial and they did constitutional law, and it really changed their lives. They're adults that are interested. One's in law school, and they're adults that are interested they're civically engaged, and they're interested in the law, and they're interested in what's right. So thank you for that. So I really, really appreciate the difficulty of this. I just want to talk about a few things so I don't just bore you to tears. You know, I love what high school students and law students do at these competitions is what lawyers should do, but think that they don't have to do. So you start off with a roadmap, and your opening statement is a roadmap, and there's a theme, and you come out strong with that theme. And then I'm always curious, will you come back to that theme and will you develop it? And this was the first round I've ever done where both teams had a theme, they developed it, and they returned to it. So I wanted to make sure you guys were going to come back, Ms. Seema, to the breaking point, and you did. You didn't return to it in your opening, you started with it, but then you circled back. And I think that is just so incredibly effective because jurors don't understand what's going on. They don't know your case, but they just want to be told a story that makes sense. And the people that tell the best story are the most successful lawyers, in my opinion. And I'm doing cases where lawyers less experienced than you guys. I am in the lowest level court in Denver. We do, municipal violations, domestic abuse, trespassing, all these violations that you like protest cases. So, you guys did what most people do. Most people don't do. You had a theme and you returned to it. So I wanted to look into the theme, the dream and a plan. And Ms. Donda, you said, ask yourself 3 questions. And then you guys returned to those 3 questions at the end. And I love that. All of you guys returned to your themes. But one thing, and I'm getting ahead of myself already, is there wasn't enough. You know, I was a defense lawyer. I represented one of the Oklahoma City bombers, and he was a difficult guy to represent. It was Terry Nichols. But you don't have good, when you're a criminal defense lawyer, your best friend is not your client. Your best friend is reasonable doubt. And you have to beat on reasonable doubt. If you're a defense lawyer, you have to wallow in it. You have to wrap yourself in it. And you have to talk about it until people are sick of hearing it. And Ms. Cook is laughing at that. But it's true. So I wanted more discussion of reasonable doubt, but that is the only, sorry, I'm like at 6 cups of coffee right now, as you can imagine. So hold on tight. But you returned to that. And I thought that was spectacular. So one thing that you guys did that lawyers don't do is you always voir dired experts. And there is no excuse on earth for failing to voir dire an expert, because that is the only time you get to basically tie their hands behind their back and kick them where they live. And that is your first opportunity to undermine them. It's like you get cross-examination before it starts. And who's going to give up on the opportunity to do that? So you all did that. And, you know, and I know Ms. Moraine is smiling, and she's a good person to talk to about this, because she understands, as all of you do, that the point of voir dire is less about getting the witness excluded and more about making the jurors think that witness sucks before they actually get to say anything of substance. So you all did an excellent job. You know, Ms. Moraine, you objected, and you made an excellent objection. I don't remember what it was. I ruled against you, but you know, it didn't matter whether you won or lost your objection to the witness. You made your points, and all of you did that. You're just one example. All of you made your points on voir dire, and that was spectacular. So to a slightly different point, you know, when you're doing direct, you make the witness the star. When you're on cross, you want to be the star. That's the whole point. You want, when you're the proponent of a witness, you want all eyes looking at that witness. And so one example, and again, I'm going to hang on just a brief second here. Well, I forgot, but Ms. Seaman, you asked a question. It was just a very open-ended question. That's what direct is about. Let them tell that story and let them say what they need to say, because often they know better, especially with an expert. They know better what they need to say than you do. So you asked open-ended, all of you did this. You had open-ended questions. You sat back and let the witness be the star. And then on cross-examination, some of you were more effective than others about putting all eyes on you. And, you know, this isn't about ego. And I want to talk about that next. But man, on cross-examination, you want people looking at you and listening, hanging on your words, not the witness's words. You're just going to say yes. You know, you're just going to ask them leading questions and shove those answers down their throat. I say this in competitions a lot, but I am lucky enough to work on an 18-judge court where 12 of the judges are women. And really, it is, I have learned so much. I wish I'd learned this about 40 years ago. But one thing I have seen throughout my career is that women are treated differently than men. That is no surprise to anyone. And so men get to be aggressive, and they're just like super aggressive, you know, but women are bitchy when they're aggressive. And what you have to be as a lawyer is you have to be true to who you are. Because when you try to be aggressive and assertive when you're not an assertive person, you look phony. And when you're just bursting at the seams, you just have to be that. You have to be true to yourself. And I thought that, you know, so I try to pay attention to that for everybody. But the truth is I pay extra special attention to that for young women, because there's the pressure on them to be different is greater and worse. And I thought that all of you were true to who you were. And I want to call out in particular, for example, Ms. Dino. You came off on cross. You were aggressive. You came out strong on cross. And it was effective for me. I thought it was very effective. I didn't like that part of men that wants to think women are bitchy when they're aggressive. That didn't happen to me at all. I mean, I fight that every day, all day. But you were just like true to yourself, and it was very, very effective. And one other comment about you is you lost some objections. You made some good objections. Your 404A, I don't think many of my rulings, they could have been better rulings, and we would have spent more time on them. But you made that objection. You knew you should have won it, and you lost it, but you were intrepid. You came back in. And it's really hard. You have to read, and this is not just with judges, this is with everybody. If you want to be successful in relationships, you have to read the other person on the other side. And so, my feeling is if you lose 10 objections, if the 11th objection is a good objection, make it. But if the judge is hostile to you in the first 10, you might not want to make it. But all of you walked that line very, very well. But read people's cues. All right, hang on just a minute. I thought all of you did well, but can really work together as a team, each of you, on how to deal with witnesses that wander and that don't answer your questions. One of you did exactly what I always tell people to do, which is when a witness for your witness, if you know your witness is going to wander for a while, the proper answer when the lawyer says, well, that's a yes/no question. And I, as a judge, when that objection is made and it wasn't made enough, when they're wondering, if you don't like it, just say, Judge, please direct the witness to answer my question. And I will. And what I would say is, that's a yes/no question. Answer yes or no. If your lawyer wants to rehabilitate you on redirect, they can do that. So make that objection if they wander. But if you're the witness who's wandering, just say, I can't answer this, yes or no. So when they beat on you, that's a yes/no question. Just say, I can't answer it, yes or no. And the judge is going to give you some love, because really, this is a search for truth, theoretically. And I know in this courtroom it is. So take advantage of that. All right. One thing that, let's see, somebody said switching gears, like you were effective in one form of questioning and then you moved on. And I think the word switching gears is a lovely way to segue. A lot of people with depositions and to some extent with trials, they have this box analogy, which is you go to one place, you've got one area that you want to cover, your prior criminal history, and you ask those questions, and then you close that box and you move on. And that's a very methodical way of doing it. And so one way you do that is you say switching gears. All right. I want to call Ms. Donda out on something, and none of this is really about what anybody did in particular. But Ms. Donda, I don't remember what questions you were, but you got some crazy answers, and you got bad answers, and you could have. It was about the timestamp on the text messages, and those answers you could have beat that to death, but you didn't. You did the adult thing, and excuse my language, you let a shitty answer stand instead of beating up on the witness and making the witness admit that it was a bad answer, which was never going to happen. You just said, thank you. And what you did was you just put that $1,000 bill in your pocket and saved it for later. A lot of people and a lot of lawyers will just argue. That was a bad answer. But what's the point of that? You want to save that for later. And you did a spectacular job. And I want to call you out for that. All right. One other thing, and I know I'm trying to talk fast and save you guys some time, but one of the witnesses I want to call is Mr. Cusack, because he was a kind of witness that we see a lot, which is a very confident, assertive witness. And with those witnesses, you're going to the best you can do is poke a hole or two. But when somebody's as confident as he is, one hole is a good hole. And, we are so trained to just beat them and stomp on them and rub them into the ground. But that isn't necessary. What's necessary, it's like a balloon. Just a small hole will pop it. And so with Mr. Dudzik, one of the things he said was, he talked about peer review and testing. And really that didn't make sense to me at that time, because peer review is more of a concept relating to somebody's expertise. You know, they've written articles that have been peer reviewed, and so they're reliable, and that suggests that they have expertise. But in the context of that answer, he said something about peer review that just didn't make sense. So if you could find one, because he was so confident, if you could find, and he was a spectacular witness, man, I'm not complaining. But if you can find one thing to do to an adverse witness, especially an expert, I mean, one good thing, because they are great witnesses, they're paid to do it, they've got lots of experience, and they're not going to say anything incredibly stupid because they know where their bread gets buttered. So they're going to stay within their expertise. But if you can just poke one hole in an expert, you have won the day. And that is something I wish I'd learned. You don't have to beat someone to death to stop them from chasing you. You just have to slow them down. And so I want that. There was a question though that somebody asked, which is, what can we conclude? That's not a proper question. It is, what is your conclusion as an expert, but not what can we as the jurors or what can we as people on earth conclude. All right. One other thing, I keep saying that, but when the experts, when you're explaining your expertise, or when you lawyers are leading your experts through, without fail, everyone talked about their expertise too quickly. And I know time is a huge issue. You guys are down to the second. But man, if there's anything you want to soak into the finder of fact, the jurors, it is all of that person's expertise. And so mostly what happened is like, I did this, I wrote that, I testified to this, and you know, I'm an expert in this, that, and the other thing. If there's one place that I want you all to slow down in the future, it is talking about your expert witness's expertise, and you know, wallow in it. Lather yourself up in it, because that's one of the strongest things you've got going. All right, let's see. Ms. Dino, you did something that I think is an executable offense. It was the only thing you did that I didn't love. As somebody who's represented some really bad people, you know, what you don't, like for example, Ms. Who was it? Hang on just a minute. Ms. Seaman, she was consistent in calling your client the defendant, because as a prosecutor, her job is to dehumanize your client. And I'm someone who's had his clients dehumanized constantly. She doesn't even think your client deserves to have a name, just a title, the defendant, the scumbag. So you have got to own that client as your, Yiddish, mishpucha, your family, someone that's important to you. And so you never call the defendant if you're representing him. And in fact, I tell people, never ever call, none of you use the phrase my client. Thank you for that. But man, always refer to your client as Mr. So-and-so, Ms. So-and-so, because you've got, the jury wants to know that you're standing behind them. Everybody wants to know that you're standing behind them, and you stand behind them when you call them by their name in the face of dehumanization from other folks. All right, well done on the thing about opinion, about how experts are paid, and they're such whores, but really lawyers get paid too. And so I love when an expert says, yes, I'm getting paid for my time, just like you, counsel. So that was spectacular too. All right, I have way more. One other thing is, you guys focused on 404B, but how about 608? So read up on 608, and 608 is a good way to get things in or get them excluded. And then you're awesome. I love doing this. I learned so much more than I impart, and I'm grateful to all of you. So thanks for listening to my fast talk and accepting my rulings. Well done.